Hello, I'm Kaustubh here. Can you hear me?
LABD 2015.
Ship's claim permission, my lord. Serial number 38 in the front. Please.
Submit to court, madam.
My lord, 2021 matter, my lord. Matter pertains to inquiry. My lord, inquiry is pertains to examination, my lord. Petition respondent herein. Writ petition in CH-2 matter. 21 matter, my lord. No, my lord, it is matter in regularly in a hearing list, my lord. Subsequently not posted. Okay.
My lord, writ appeal 1157/2023. It is dismissed for non-prosecution of case. We have filed recall application, my lord. Memo will be filed.
My lord, commercial application, my lord. Suit, the court has decreed the recovery of suit. There is decree for recovery of money, my lord, 10 lakh rupees, 10,40,000 rupees. And the decree is based upon the checks, 8 checks issued by the defendant. Now the matter is being proceeded for attachment of properties. That's so we are moving this application for urgency of the matter. Fresh matter. Yes, my lord, all the objections. Yes, my lord. Yes.
That's 23 matter. That's 23 matter, my lords. Increments granted have been withdrawn to BESCOM employees. I've challenged that order. Is there anything? I've already filed. Please. I've informed my lords, I've taken the consent. I've informed my lords, early hearing application has been allowed. The matter has to be. Please. There's no.
Page number for adjournments, page number 7, 22 to 25. Page number 8, 26 to 27.
My lord, serial number 27, my lord. My lord, it is for depositing the award amount.
I am for the respondent.
I seek a 2 weeks adjournment, my lord.
I request for an earlier date, Your Lordship. They had to deposit the amount, and for that they had to take instructions. Your Lordships had heard it on 5th of February. The appellant had to take instructions
have
on
already-
what amount they would deposit towards the award amount.
My lord, we have already sent the communication to the ministry. We are. Please, my lord.
I'm grateful,
9th of April.
grateful.
Serial number 40, my lords. 40, my lords. I'm appearing for the appellant. My lords, the arguing counsel is not in station today. May I request for any date next week, my lords? I've informed the other side.
We have 41. Second.
Much obliged.
Serial number 41, my lords, for respondent number 1. Seeking an adjournment. My lords, I'm for respondent number 1. Seeking adjournment to place our objections on record to the appeal. To place on record the objections, my lords, we need 4 weeks' time. Indeed, my lords, we'll file 4 weeks' time. Well, I've informed the other side, they've not appeared. I've informed, my lords. Respondent number 1, my lords. Indeed, my lords.
Your names. Your names. 11/6.
Serial number 38 in the final hearing list, madam. Matter is already settled. We have to report for settlement. 4 weeks time may be granted, madam. The respondent counsel is also present. We have given a proposal. No, we have given a proposal. That proposal has been put forth to the main head office, madam. Four weeks time may be granted.
11/6.
Okay.
Serial number 1.
Number 43. Yes. 43. Yes. 43. For respondent, who is for the appellant?
Shri Gangadharappa. Serial number 1. Shri
For the
Sanjay Krishna.
appellant. Lordship. This matter had come up before your lordship earlier. This pertains to acquisition of certain lands under the ITIR scheme. In fact,
My lords, I have filed my objections today, my lords. I am most. Please, my lords. For the IA, my lords, and also to the main writ appeal, my lords. Because we had taken a stand in the last occasion, my lords, that we had taken physical possession of it way back in 2023. And also 28/8 order has also been passed, my lords.
I make one submission. For the first time before this honorable court, they are saying that they have taken possession in the year 2023 itself. In fact, as on that day, an interim order was operating in my favor. Throughout the petition, until it was disposed of, the interim order was operating in my favor. My lord, if your lordship takes the first petition, your lordship may kindly see on 9/6/2010, the preliminary notification was issued. Rejoinder, I would like to file, my lord, but the problem is they have not taken physical possession. In fact, we have obtained. I will say that, my lord, but the only difficulty is, my lord, they are now coming to take possession now at this point of time. In fact, I have been served only now. I will, my lord, may I request one thing? Let there be an order of status quo until then, my lord. Otherwise, what happens?
Well,
That's right. We will be the status quo.
My lord, they say that as on the date, there was an interim order operating in my favor. If they have said that, my lord, may kindly see their objections for a minute. No, I will file, my lord, but the difficulty is this, My lord, may I request for shortest possible date, I will file my objections. Yes, shortest possible date, because my lord, 1 week's time, my lord, 1 week's time.
Please, my lords, it is filed. I am just.
My lord, 1 and 2, both. It's a common order, my lord.
Please, my lords, that is another petitioner counsel is, appellant counsel is Priya Shetty, if I'm not wrong.
See, well,
My lordship, that is a serial number 5, which is WA 620. That is also same nature of matter, my lordship. But the case has been posted as a third time objection, my lordship.
Here for whom?
I'm for the petitioner, my lordship.
Very well. Now, are you filing objections in this also?
My lords, there was no notice ordered. I am anyway on caveat. I'll file my objections. I have filed objections for 1 and 2, my lords.
You appear
Not
for
admitted.
respondent number?
3 and 4, my lords.
Who are those 3 and 4?
Special Land Acquisition Officer and KIDB, my lords.
Oh. No, there is no notice in this. See, then all 3 have to go together. That's right.
so it's a
Now
common
you
order.
appear in 2, item 2 you appear.
1 and 2.
So now these objections are for 1 and 2 or only
Please,
for
my lords. Only 1 and 2, my lords. Both I have filed.
For item 1 and 2?
Please, my lord.
Oh. Just say this, learner counsel appearing for respondent number 3 and 4 in both the matters.
Please, my lords.
States that she will file the objections to the stay application,
Stay application along with the writ appeal, my lords.
to the writ appeal oblique the stay application in the registry during the course of the day. She has given a copy thereof to the learner counsel for the appellant in these 2 appeals. He states that a week's time be granted to file a rejoinder to the same. Full stop. Item 5, just say this. In item 5, we'll issue notice on this. This also arises from the same issue.
Same order. Common order.
Issue. Though 2 objections have been notified by the registry, this notice has been issued in WA 50424 and 58424. We deem it appropriate to issue notice in this appeal. Notice so-and-so accept notice for Mr. Kumar for union of 1, 2 is madam, then 3, 4. You would be appearing, ma'am.
Please.
They have filed caveat, I think.
3, 5 is
I think they have entered caveat.
same, you will appear. And who is for 6? Bhagwantappa and Anjana Murthy. Let notice be issued to respondent number 6 and 7. Returnable on. Ma'am, what is the? But they were co-petitioners.
Yes, my lordship, they were co-petitioners.
Oh.
And since we have to make them as a party, we just been.
No, we are issuing
Yeah,
notice, or you don't want us to issue notice?
No, my lordship, they have already compromised and they have already taken money from the KIDB. No notice may be issued to them.
So you say so, dispense with the notice.
Yes, my lordship. Yes, my lordship.
Just say this, learner counsel for the. Six and 7. Oh, we will 6 to 25, we will dispense with.
Yes, my lordship.
Learner counsel for the appellant states that the respondents 6 to 25, who were the petitioners, no notice is required to be issued. Noting this said submission, notice to respondent 6 to 25 is dispensed with at the risk of the appellant.
Much obliged, my lordship.
Okay, then you will file also?
File my,
You will adopt the same thing or you will adopt different?
we have to go through the petition, my lords.
Just go through and give a copy also.
Yes,
The
ma'am.
learner counsel for the respondents 3 and 4 states that she shall file objections within 10 days from today
Please, ma'am.
in this appeal as well. Rejoinder be filed within 1 week thereafter. Just
Much
10 in
obliged.
1 week, just give it after 17 days.
26-3.
Much obliged, my lordship.
My lords, in serial number 2, my lords.
My lord, may I request
Counsel for,
25th instead, my lord, 26th I have some inconvenience.
Okay.
25th instead.
my lords, in serial number 2, my
Right.
lords, the counsel appearing for 3 and 4, the name is wrongly shown. Anuparna, my lords, as it is shown in our serial number 1, item number 1, my lords.
No, whose name for which
For respondent
party?
number 3 and 4, it is Anuparna Burdoloi. It is written Annaparna Burdoloi, so it is.
It's Annapurna.
Anuparna, my lords.
No, serial number 2 it is correct, my lord. Serial number 1 it is wrong.
The name of the counsel for the appellant.
No,
For the respondent 3 and 4
Please, my lords.
be corrected as Anuparna Bordoloi
Please, my lords.
instead of Annapurna Bordoloi. Okay,
25th, my lord. Correct.
Serial number 3, party in person.
Much obliged.
Your Lordships, I am Kaustuba S. Goody, and I am the appellant, and I am appearing as party in person in this matter, Your Lordships. And I sincerely appreciate the opportunity to present my case before this honorable court, Your Lordships.
yes,
My appearance has been formally accepted, and I have been issued Form C in compliance with the rules for party in person, Your Lordships.
yes,
I respectfully submit, Your Lordships, that there are 2 writ appeals in the present dispute. Writ appeal 682 of 2024, which is the present one. Another writ appeal 691 of 2024.
when is that listed?
It is currently not yet listed, Your Lordships.
So you are the petitioner there, appellant there?
I am the appellant in both these writ appeals, Your Lordships.
So why don't you get it listed?
Yes, Your Lordships, I will be doing so, Your Lordships.
So what
I
do you
respectfully, I respectfully submit, Your Lordships, that both these writ appeals 691 of 2024 and 682, they arise out of 2 separate but intrinsically connected judgments, Your Lordships, delivered by the learned single judge in writ petition 49970 of 2018 and 42874 of 2019, which were also connected with writ petition 20306 of 2022. Despite, Your Lordships, the undisputed factual and legal commonality, the learned single judge has delivered separate judgments instead of rendering a single judgment, Your Lordships, resulting in severe.
Were these petitions heard together?
Yes, Your Lordships. And due to the rendering of 2 separate judgments instead of one, it has resulted in severe prejudice to my rights, Your Lordships. The core issue before this honorable court pertains to
Just 1 minute, just 1 minute.
Yes, Your Lordships.
What is your good name, Mr. Goody?
Yes, Your Lordships.
You do one thing, get the other appeal also listed.
Okay, Your Lordship. Yes, much obliged. Your
We
Lordship.
will give a date here.
Okay, Your Lordship.
After you clear the objections, that has not been listed at all, no?
That was listed twice or thrice, if I remember correctly.
What is the date of hearing there?
Somewhere in the month of December 2024, Your Lordships.
No, how can that be? That date has gone now. What is the
Yes.
future date?
They did not provide a next hearing date for that writ appeal, Your Lordships. So it has been lingering over there.
Oh, Is it 691 of 24?
You're right, your lordships. Yes, that's correct. I request your lordship that these two writ appeals be connected because of the commonality, legal commonality in both the issues. And since the learned single judge delivered two separate judgments erroneously without considering the merits of the application, your lordships. And your lordships, both writ appeals originate from the same factual and legal background. Filing two separate writ appeals, your lordships, with identical legal grounds is procedurally redundant and would amount to an abuse of judicial process, your lordships. Therefore, connecting both these appeals ensures judicial efficiency and prevents contradictory rulings on the same legal issues, your lordships.
Just one. Now, though it appears that appeal is lying under objections.
Yes, your
So
lordships.
remove the objections. We will give a date in this appeal
Yes, your
and
lordships.
get that appeal listed on that particular date. But after removing the objections.
Okay, lordships. Much
Okay.
obliged.
Just say that at the request of the appellant. Re-notify and give it in April, ma'am, second week or so.
22/4. Sir,
Can I get an
22/4.
Can I get an earlier date, your lordships?
We will give it. Suppose that appeal objections are not removed.
I'll make sure that they are removed as soon as possible, your lordships.
First week, give it in first week.
Sir, 8th of April, sir.
Thank you, your lordships. Much obliged.
Serial number 4. P. Karthikeyan.
In this matter,
Four.
my lordships on the last occasion had requested that how different this particular matter is with respect to the order that has been passed, my lords, before the division bench. Before the division bench, my lords.
Yes.
Please, my lords. My lords, I would only want to respectfully submit, my lords, that there is an SLP that is pending, my lords, which is pending on the SC/ST land, wherein I'm asking for revocation of the land after a lapse of 16 years, my lords. My lords, on the same order that was passed by the Honorable Division Bench, my lords, I just got it yesterday, my lords, if I may pass on the diary number, my lords. Please, it is for, please, my lords, I'll get those papers, my lords.
No, I have not, because this is different, my lord. Actually, in identical matters, your lordship knows all the writ appeals have been dismissed on the ground of delay alone.
My lords, diary number 10370 of 25, my lords. The SLP that has been filed, my lords. Yes, my lords. Yes, my lords. Yes, my lords. It is slated to be posted sometime post holy vacations. Please, my lords. Post holy vacations it is going to be listed, my lords. Is my
Is it on the?
same revocation of, please, SC/ST lands, my lords. PTCL land. Yes, my lords. I'll provide the documents also, my lords, on the next hearing.
On the ground of delay,
Yes, my lords, on the ground of delay, my lords.
maybe following the Millard, following the Millard earlier judgment of the Honorable Apex Court, your lordships have decided number of cases. That's it.
Please. It's been filed on 24/2, my lords. Please. If I may request for 4 weeks accommodation, my lords, I'll provide the documents also, my lords.
Yes,
Please, my lords. A week's accommodation, my lords, I'll get those.
today afternoon, your lordship.
Today, tomorrow, my lords, if I may request. Please. 10370 of 25, my lords. 10370 of 25.
ascertain. I'll ascertain. I will ascertain.
Yes.
Please.
Serial number 5 adjourned. 6.
But suppose. My lords, I'll remove the office objections, my lords, a week's time may be granted. Remove all the office objections. That's my learned friend will appear in this matter. Please, madam.
Twenty-one-4.
It was 13 also, my lord. I'm
I
sorry.
beg your pardon, my lords.
Please.
Serial number 13 also.
4 and
4 and 13 are connected. Please. Yes,
yes, yes.
please.
Anyway,
Great.
7.
Lord, you need an arrangement to file application before the learned single judge. So far as correction of names is concerned, last time your lordship has suggested, directed me to think over it, because there are names of the appellants have been wrongly shown in the order of the learned single judge. So now I have filing an application before the learned single judge.
23-4.
Please.
Serial number 8. The servants.
For the
Number 8.
petitioner in this case, madam, short accommodation, I will complain office objections. Office has read additional office
My lord.
objections. 2 weeks time,
10-6.
please.
Serial number 9. Praveen Kumar.
Lordship, I permit to withdraw the appeal. Please. Please, please. Grateful.
Serial number 10. Usman. 10.
Appearing for the appellant, my lord.
Yes, ma'am.
Appearing for the appellant, my lord, the office objections had not been complied. A second copy had to be furnished.
Twelve six. Serial number 11. Shri Vishwanath. 11. Twelve.
If I appear for respond number 1 to 138, my lord. And this is the matter wherein your lordship land was acquired by them, your lordship. Thereafter, they did not pay the compensation. They decided to issue TDR. In fact, your lordship, the planning authority recommended to issue TDR, but the BDA refused to issue on the ground that the issue is insofar as 14B of the Town and Country Planning Act. They say that, your lordship, this land is acquired in the year 1974, therefore I am not entitled for the TDR. So last occasion, we have submitted the written submission also. We are ready with the matter.
We are also ready.
Pass. Please, your lordship. Please, your lordship.
Please.
13. Fourteen. 14.
Excise matter.
15,
Petitioner in this case, my lord.
Chandrasekhar.
First respondent has filed caveat petition, my lord. And the second objection I have complied on 18-1. My lords,
Send it back to Mukteshwar.
no, my lord, what I'm saying is they filed caveat petition, my lord. They filed caveat petition. Yes, my lord. And I've complied the office objection, second office objection also long back, my lord. That is on 18-1. Yes, yes.
It's your merit.
Let them come on record.
You take a submission, it's your opinion.
This is, my lord, they are experts in particular diseases, my lords. Therefore, thereafter from Mukteshwar to Bangalore, they have to. That is, a disease comes for the mouth of the oxes. There. But this, there are two scientists in Bangalore. They have transferred from Mukteshwar to Bangalore, my lords.
It's IPRI elsewhere.
It is there. It is there, my lord. But these two scientists are very experts in this particular disease.
Where do you say in your opinion?
That is ground number 17, my lord.
Yes.
The tribunal ignored that the respondent number 1 service in the completing PPR project is more essential. The respondent number is having vast experience and knowledge in the field. Respondent number role in eradicating the virus, that is blue tongue, in the country is most important. That is the ground. No, they filed caveat, my lords. Not yet, my lords. I served a copy to the Union of India, 2 copies.
Forget Union of India, about the respondent number 1.
I'll serve it, my lord. Personally, see, they are my officers. I'll maybe permitted to serve personally. Yes, my lord. Today itself, I serve, my lords. Yes, my lords. By hand.
Sir, 15 ಅಲ್ಲ?
15.
12-6.
Both by hand, my lords. Both by hand and court also, my lord.
12-6. Serial number 16, Srinishan.
Date,
12-6, sir. 12-6.
12/6. Short date may be accommodate, my lords. It's a disease is like that, my lord. It's in North India, most of the access are facing so many
9-4.
diseases. In North India, the oxes are facing a blue tongue problem in North India. That's why I'm requesting a short date for this. It's a tongue problem for the oxes particularly.
84, sir.
Much.
Serial number 16, Nishant.
For the rest,
I appear for the appellants, my lord. I pray for a week's time, my lord. My lord, my senior is unwell, my lord.
for the respondent in this matter.
A short date may be given, my lord. My lord? Advocate Akash, my lord, my lord, he's extremely unwell. A short date may kindly. He's extremely unwell. A short date may. Please, my lord. Any short date may be given. Monday, my lord, Monday.
Humble submission, Lord. Prashant MB undertakes to file wakalat for the respondents in this matter. All the five respondents, my lord. Yes, my lord. Vandana Tayal, Praveen Kumar Tayal. Prashant MB. Yes. We are coming on change of wakalat. At least the date maybe can short.
11-3.
Obliged and grateful.
Much obliged, my lord.
17.
Your
Serial
Lordship,
number
in this-
17.
In this case, I'm appearing for the appellant. also. Your Lordship, kindly pass out the matter. Application has been misplaced. Kindly pass out. Kindly pass out the matter. Application has been misplaced. Right.
18, Shri Aditya. Here for the respondent.
And for the appellant. My lord, on the last date of hearing, no, my lord, we did not fructify. So, my lord, this is a suit that has been filed by a firm.
There is a cross objection filed by me. I have not preferred anything.
Yes.
Please let me confirm, my lord. I had come to argue the matter, my lord, on the merits. Yes.
What is the IA pending?
This, I'm not aware of this, my lord. I genuinely am not. I see IA number 1 and IA number 2. Warrant to possession of state, yes.
I filed objection. To a limited portion. To the extent, my lords, that it does not refer the parties to final decree proceedings, because what the court does.
That's right. Let's see this, recall application.
No, my lords.
Just, you have.
I don't have it actually in trial. I'll make efforts to get it from the office.
My lords, I think because they were constantly changing counsels on the other side, this is not something that my learned friend has done.
Just see this application. Just see this application.
Yes.
Understood. My lords, that application seems to have been filed because initially, my lords, there was a conditional order of stay by this honorable court operating on the judgment and decree by the trial court. My lords, that stay was conditional to the effect that the payment, whatever is in dispute, shall be deposited into this court within a period of 3 weeks. My lords, subsequently, we filed cross objections saying that the decree, nothing has been deposited. So the stay got vacated. My lords, in fact, what has happened in the matter is due to efflux of time, my lords, stay got vacated, after which we filed an execution petition. Part of the decree, my lords, for eviction has been successful. Possession granted, we've taken possession, my lords, bailiff came to the property.
Yes, only on the main. Yes.
Only on main property.
Till the date of vacation.
Till the,
Date of vacating.
please, till the date of vacating the property.
So now it is your prayer also. See that prayer.
Yes.
You also say relegate the parties for an inquiry.
Yes, to some, yes, to some extent, but I would like to also make certain arguments on the main petition, my lord, if that is permissible. Yes, but my main arguments are with regard to what has been granted as rent and that aspect of rent. So it's, the arguments with regard to possession, of course, is moot at this particular point. But I would like to put forward the arguments about what was the nature by which the trial court has granted this order for rupees 45,000 odd per month till the grant of. That's correct.
Been granted 45,000 is subject to the inquiry.
Please, please.
Right?
45,000 is because of the first loan, the lease agreement, which is in 2015.
Minded. Don't know whether you will be able to contest 45,000, that's based on
Right.
something in the lease.
Please.
Yes, yes, my lord. But my submission before this honorable court is that the trial court hasn't given us a fair shake with regard to issue number 1 and issue number 2, which is establishing a jural relationship between the plaintiffs and the defendants in the trial court, that is the appellant and the respondent here. What I put forward before this honorable court is that the jural relationship itself, that is under section 109 of the Indian Evidence Act, the burden of proving the existence that this respondent is my landlord, I believe I've not been given a fair shake there.
They were the tenant. I am
I'm
the
the
landlord.
tenant.
Be clear. You will not
My lords,
you have located it, that's a non-issue.
they have retained the property for 20 years as tenants. My lords, to now turn around and say I am not the landlord. My lords, the
The appellant here,
appellant only.
you have executed.
I am the managing partner of the firm that owns the property.
But,
Please.
but But my lord, if I just may.
That has been answered.
And I don't believe we have been given a fair shake before the trial court looking into the cross-examination. But my lord, my submission is if the trial court has framed 7 issues, of which 4 issues depend on establishing the jural relationship, and that when the trial court has gone through the entire documentation as well as looking at the cross-examination. Yes, the finding on issue number 2. Yes, ma'am.
It should come down in 36. Your case is rent collectors. Whether rent collectors or so, you would not challenge who is the landlord. You will not contest. That's the law is well settled. You will not allow that to happen. Even what is the finding?
So that is page number 36, Manu?
Firm's account.
Please.
The comment was being made in the firm's account.
So, my lord, if I may be able to just give nuance to the facts of this particular case, and just establish to some extent what is the point that's trying to be put forth. The lease agreement has been entered into by us with 2 individuals, both husband and wife. This was a 11th month lease agreement. Following which it came to be known that these 2 individuals who have represented themselves to be the landlords were not the landlords. And that one, Mr. PM Chako, was the landlord. Now, as per PM Chako's instructions, he said, please deposit this amount of money in the joint account of these individuals. Now, there has been clear and express admissions, both by PW1 and to some extent PW2, that Mr. PM Chako was very upset that this property has been transferred into the name of the firm. There is a document to that effect, which is D4. So what has happened? Yes, my lord. But then it is an admission of fraud that has happened over here. Yes, my lord. See, my lord, what I am trying to establish over here is that if they do not own the property, then there isn't a jural relationship.
Details. When there,
Mhm.
right?
Well, at page 36.
Para 45.
Para 40.
That's the right finding. So now you have vacated.
Yes, it's been vacated.
We want to do cases, topics as now finally.
Yes.
The directions, the terms of the rules. You still want that it's the more.
My lords, indeed, my instructions are that this amount that was 45,585 is stemming from the very first lease agreement that was entered way back in the year 2013. My lords, those rates are not what prevails in Koramangala today, where the suit schedule property is situated.
Case is now, High Court could not have stopped at, by granting only 45,000, what was agreed. The event had increased, so that the inquiry had not been directed. To that extent, Harshad.
They have in fact conceded to that ground in their appeal also, my lords, at para 36 of their appeal. One of their grounds, my lords, para 36, if I may read. Honorable Trial Court has failed to note that the respondent had only sought for enquiry into mean profits and in the plaint had not quantified the amount. I'm reading from their appeal. Para 36 of their appeal memorandum at page 14. Commercial appeal, my lords.
In your opinion?
No, I don't have a para. This is the. It concludes at para 20. See 26, 27. Huh. My lord, it's actually misnumbered on para number.
It's 22. Para 22.
So that's page number 13. What should be para number 23 is, should be para number 30.
My lords, in the copy given to me, I believe it is before compliance of office objections. It says 36, but my learned friend is saying it's 22.
23. 23.
Then one para before, after that, my lords, 23, where he is referring to order 20, rule 12. Please. 28. It's anyway. So to that extent, they are in agreement with us.
So say there should be an inquiry.
Yes, well.
And to your benefit, suppose it is not the same rate between the rates that comes down. We will dispose of both.
Please.
It's unlikely in Bangalore, my lord, but.
Unlikely.
It's
the
unlikely
area
in
question,
Bangalore,
my lord,
but-
that there is a.
What you say in paragraph?
My lords, in fact, if I may just submit this also, we had taken efforts, my lords, by applying for the EC in the entire area, comparing the registered lease agreements in the area. It's way more than this amount. Please.
They say this must be a big,
Okay.
My numbers are all.
As stated as, in other words, as stated as the opposite in substance, in case of the appellant in the opposite paragraph, needs to confess the quantification of the mean profits by the trial court. At 44. $44,585.
45,580. 45,580.
45,580 per month. The sale is not have been granted. We find that collected of the two of the following by the respondent to be included judgment between the extent that the learned trial court does not fight with where is your claim?
That's plain. I have not produced separately. We had played for me. Manoj, I had, my mistake, Manoj, I had simply said call for trial court records in one of my prayers.
There's no prayer for me.
There was. Manoj, in fact. Manoj, because issues framed, Manoj, by the learned trial court. One of the issues framed is whether I am entitled to mean profits as paid for.
It's not there.
No, Manoj, no. I'm very certain. At page 29 of my cross objections, Manoj, where issues have been extracted by the learned trial court. Sixth issue. In the cross objections, at page 10 of my cross objections, ground C. Para 24 onwards, my lords, till para 30. Page 10 onwards, my lords. Para 24. If I may only interject for one moment, there is a finding, in fact, by the learned trial court at para 50. Please. Please, I had in fact made a specific plea for 60,000 rupees. Please, she rejects that. She rejects that saying, no, this is the mean profits I'm giving, instead of sending it to an inquiry.
No, my lord, my contention has always remained that there is we are contesting it based on rural relationship. This court has found on that aspect. As far as the means profit is concerned, it is the direction. It's also been conceded the role of die before the trial court based on an inquiry, and hopefully it works in our favor.
Para 23, my lords of the, sorry, 53 of the impugned decree.
4.
53 and 54.
53 and 54.
Could have been decided. The following few inquiries. The second inquiry is very large. So it may so happen, even the mean profits at the rate of 4,5,585 will not be able to maybe appellate this. Within this set submission, we look at what we have to stating that we are confining to 60,000.
Well, I don't have instructions to confine it to 60,000. If it's an inquiry, my lords, if it's an inquiry and it can result in reduction both ways, I don't want to confine my lords to 60.
So if it is 60,000.
My lords, that 60,000 was an approximation that we had indicated at that period. My lords, based on, I agree. But if it can be left open, my lords, we will demonstrate in the inquiry as to what is the exact figure. My lords, very well. We can't be the poorer for it. We can't be the poorer for it if it is between 60 and 45. I don't, it's okay, my lords. We can't be the poorer for it by agreeing to 60,000. It's all right. We can confine to 60,000 and contest on that. Please. But I have only one observation there, my lords. The learned trial court, other than not giving us the opportunity to go to an FDP, has also not granted me interest on the pending amount. Interest, my lords, is an automatic consequence of delay.
We answered in the inquiry as well.
Please. So when my lords are.
You are saying on 4,5,585, that interest has not been granted.
And the amount that will be then found in the FDP proceedings, my lords, because if that is the mean profit, interest has to be calculated on.
This is 60,000 as mean profits. Respondent states that the respondent or entitled to the interest is non mean profits and also by the court. First to state, since we are delegating the artist.
So, my lord, so the submission is that it's probably 60,000, but it's definitely more than 45,000. So.
Yeah, but anything before 60,000, they can't even.
All right.
I have full confidence on Bangalore real estate. Full confidence on Bangalore real estate.
The process of an inquiry to determine issue number 6 as framed.
Five eight five. My lords had asked for the date on which possession was taken, 22/7/2023. 2023. Grateful, my lords.
Much obliged.
19. 19, Shri Suhas. 12/6. Till number 20.
Yes, I'm applying. I've had an application to recall the order dated 4/11/2024, my lord. Will what this be?
It was dismissed, my lord. Yes.
Yeah, all small, my lord, I will complain within 1 week. I will complain. Yes, ma'am. Public.
6. 21, Shri Somsekhar.
Appeal for the appellant, my lord. I have filed a memo, my lord, to convert the appeal. It's not maintained. Your lordship pointed out last time. It's not maintainable. Therefore, I have filed a memo to convert it, my lord. So it fits. My lord. That is order 9, rule 13, application was allowed. If it is rejected, the appeal was maintainable. So I examined it, my lord. Writ petition, my lord. I have, your lordship has passed order. I will enclose it to the memo. My lord. Similar order passed by my lord in another case, my lord. Richmond. Yes, much obliged.
Serial number 22. Nitin Prasad.
Lord, suit for specific performance. We are agreeable, my lord, for the builder to develop. He is on KVL. We are the landowners. Agreement was entered into for joint development. We have no problem, my lord. Though we filed the petition, my lord, since he is on KVL, we are agreeable. Let him, my lord.
He initiated arbitration.
He initiated the arbitration. And we have no problem, my lord, with him developing. Developing the property, my lord, because he,
JDA was entered.
as per the joint development agreement, he is the he was supposed to develop the property. Initially, my lord, we thought, my lord, there was some dispute and all that. Now we have no problem, my lord, with him doing it, because the dispute, my lord, got resolved because somebody else had filed. Whether, my lord, they are willing to go ahead with the joint development.
I
or
need
not,
to
they'll have
take
make a
instructions.
statement.
I need to take instructions. This is first time brought to the attention of this court. I'll take instruction from my client. I respond number 1, you know, who's the claimant with
Notice, my lord, emergent notice, if your lordship permit us. 9.
they are the LRs.
My lord, arbitrators, my lord, 7
Can be.
He is, my lord.
He's
Idiot.
only surviving us. No more. You remove their family members.
Of whom?
They are appellants in the other.
Tribunal of 3 arbitrators.
Because
Other two
Justice,
passed away.
yes, Justice Shiv Shankar Bhatt and
Shri Venkatachala.
Justice Venkatachala, they were the other arbitrators. They passed away. So, my lord, we can- of course, my lord, this is because our rules specify that they must be made a party. Otherwise, my lord, it becomes, normally we don't make judges, but the our High Court rules. Because what the idea was, you may make some allegations against them, my lord, of misconduct, but then, my lord, if there is, my lord, your lordships will look into it without them saying anything. Correct, correct, absolutely. But anyway, my lord, we have no choice.
I'm a pen, I have file escape. 8, 9.
8, 9, and 11, they are appellants in the other field. Yes.
Connected.
They would all jointly respond in the Well, I am appearing in the companion appeal. That's right. 207. We will mark the evidence, not those. Just say this.
207 I appear.
Dated 9 was that also. So in 207.
No, my lord, that he is on KVX. So, my lord, we said, we thought the matter, if it could be resolved.
210. 210. The 207. This is the first.
The first.
KVT.
ಇದೊಂದೇ ಕೊಟ್ಟಿರೋದು. Doesn't matter.
Now, who appears for 8, 9, 10, 11?
8, 9, 10, 11, will you take notice? Correct, 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 correct.
Since they are appellants, notice may be dispensed with them. Right, yes.
8, 9,
8, 9,
10, 11.
Who appear?
Yes, yes.
They say that so-and-so acts of notice for 8, 9, 10, 11. Who are the appellants in the connected appeal being 207 or 22?
2020.
Right? So we let the counsel for the response now.
One minute, second appeal. Second appeal is this one.
Now you appear for one.
I'm for the appeal.
Recording both.
Appear only on record for appellants.
Then you ask for dispensation.
Who is for 2?
2, 3, 4, 5, and 6 notice may be directed.
Now, who appears for 2, 3, 4, 5, 6?
My lord, notice is not got to them.
Issue notice to 2, 3, 4, 5, 6. Then for 8, 9.
They maybe dispense with because they are already there on in the other matter.
But of the access notice for 8, 9.
Because
My
what
lord,
has
I am
happened is.
on record for both, in both appeals for
That's
the
a-
appellate.
So therefore,
It will be a little,
Oh, is it so?
yes, sir.
therefore, my lord, your lordship may dispense with the.
Therefore, my lord,
Then you accept notice in that, why is she accept?
No, she is my colleague, only, but problem is no need.
Yes, ma'am.
8 and 9 are the appellants in the collective appeal. This is the respondent is dismissed. So you will say that also in the.
Yes, madam, please, great.
Now, the request of counsel for the respondent number 1 to take instructions.
Please, yeah.
First time.
2 weeks, yeah.
Please.
indicated date, my lord.
26/3.
Please, please. Great. Much of.
Three, Harish Kumar.
My lord, I appear for the appellant in this. My lord, I seek for short accommodation. I need to place, my lord, written submission as well as citations. Short accommodation.
My lord, I have,
13/6.
my lord, I have filed my state objections, my lord. It may be taken as my submissions.
Right?
I have. Bless.
13/6.
Acha.
Serial number 24.
Appearing for the appellant in this case, my lord.
Taxi council of respond number 5, my lord. Respond number 5 council is unwell, my lord. Kindly next week, any date, my lord. Taxi council.
This is a short point. Plaint has been returned since it is a commercial dispute. Any short date because of medical reasons, I do not think I can. My lord, what has happened is, my lord, it is a commercial dispute. If my lord may kindly take to the My lord, the plaint has been returned and the OS has been treated as disposed of, and therefore I have no other.
If we complaints and appeals, where 710 is allowed, then plaint is open.
Yes, my lords.
Arguing council, my lord. Some inconvenience, medical reason, my lord. Some inconvenience. Respond number 5.
ಕೆಲಸದಲ್ಲಿ ಅವ್ರ ಮೈಕ್ ಕ್ಯಾರೆಲ್ಲ ಹೊಡ್ಕೊಂಡಿದ್ದಾರೆ. ಹೌದಾ?
My lord, any shorter accommodation, my lord?
8th of April.
Yes, my lords.
25/3.
Much obliged, my lords. No, my lord, this suit itself is a suit for recovery of mortgage, and as a deposit of title deeds, there were lands that were connected. Yes, my lords, because money lent is for a business purpose. There's an agreement executed by the parties declaring that the money lent is for the business purpose, for the business of a partnership firm. And a mortgage deed also has been.
25. Sri Raghavendra.
For the respondent. Plaintiff.
I am the plaintiff respondent, my lords, in this case. My suit has been decreed. It is the appellant, they are seeking to produce additional documents. My suit has been decreed. They are in a challenge against that decree. They are seeking to produce additional documents. We have filed objections to that, saying that they are much.
Twenty-six.
Lords, this is that, my lords, the writ, my lords, has been listed before Court Hall 1. Because, my lords, the order of the,
No, my lords, these appeals arise out of the interim order that was granted, and thereafter an interim order was granted by this honorable court permitting the action of the debenture holders to act under the debenture trust deed.
my lords, my lords, can I just make one submission?
Last occasion, that rate has to be withdrawn. Ideally, your lordship said, ask them to withdraw it. They wanted 2-3 days time.
My lords,
So let
yes.
these commercial appeals be there. My learned friend wants time because he wants to file another commercial appeal against the recent order passed by the commercial court.
The order, my lords, the order, we are likely to get the order today. My clerk is in the commercial court. 17th, my lords, I think it's convenient to everybody.
Please, 17th of March.
Pledge.
Pledge.
My lords, interim orders have to be extended in their favor. In this sense, yes.
Extended in the next.
Twenty-seven adjourned. 28. Serial number 28.
For the appellant in this case, your lordship.
For the respondent, my lord.
Your lordships, the last date of hearing, your lordships had opined that your lordships would be willing to send the parties back to the learned arbitrator. This is a matter where section 9 order has been confirmed as against the respondent in the matter, which has been extended up to the closure of the arbitral proceedings itself, your lordship. Our humble request would be for your lordship's consideration on the fact that there is a very limited scope to provide certain interim reliefs for the parties till the learned arbitrator can consider the facts and circumstances of the case. Respectfully, your lordship, because it is an order of the honorable court, and if your lordships would be willing, please, your lordship.
May I request your lordship to turn on the mic, my lord? I'm so sorry.
Yes.
Apologies.
Now, what being suggested is, this is an appeal against section 9. There is an order passed in your favor. So the counsel says that because since that's an order of the court, the arbitrator may not be able to do it. We may not be able to agree with that. The liberty can be given by the court to file an application seeking modification, variation, vacation, and the arbitrator will consider. We can't have two parallel proceedings, one there, one here.
We are
Let's
deeply
be clear.
respectful of your.
So you agree there? You agree for that?
Please, my lord.
So
Please, your lordship may only consider the fact that there is a specific direction for deposit as against us, your lordship. And the honorable arbitrator has already proceeded to consider the issues in the matter and framed issues in the matter also. And we are in a stage where the evidence is to commence in the
so
matter.
we will see there is a deposit. Otherwise, if there is a deposit, they can seek enforcement.
Please, your lordship.
They can seek enforcement.
Please.
But now he's saying that liberty be granted, you will file an application for the arbitrator to consider.
My lord, the order as well, there is an alternative to provide bank guarantee as well, my lord.
That's right, there is an alternative.
Respectfully, your lordship, the first paragraph of the judgment which we are requesting your lordship to consider, it specifically notes the fact that whether the respondent here admits that or not, the judgment itself specifically notes that only the balance amount is not paid as per the case of the respondent herein, the applicant.
Just say this 28. The challenge in this appeal is primarily to an order dated 20th of August 2024, whereby the so and so additional city and sessions judge has decided an application filed by the respondent herein under section 9 of the Arbitration and Conciliation Act 1996 and directed as under, and directed the following, that we'll see at page number 39. Full stop. We have been informed that a learned arbitrator has been appointed who is seizer of the proceedings, who is seized of the dispute. If that be so, appropriate shall be, if that be so, and agreed by the counsel for the respondent, that liberty shall be with the appellant herein to file appropriate application for vacation, variation, modification of the impugned order dated 20th of August 2024 before the learned arbitrator for his consideration. Okay?
Grateful.
His consideration, full stop. For consideration, full stop. We suffice to state that all the pleas of the parties, both on facts and in law, are left open to be canvassed before the learned arbitrator. Okay, with the above, we dispose of the appeal.
Grateful.
Please.
Thank you.
Grateful for your consideration, Lordships.
29.
My lords, this
The
is a
respondent, my lord, I'm on KVL.
defendant's appeal, my lords.
Yes.
My lords, defendant's appeal. My lords, the judgment passed by the commercial court is in challenge. My lords, the defendant, my lords, that's the appellant, was an owner of property, my lords, measuring about 120 feet by 80 feet. Behind this property, my lords, there was a marginal land measuring about 18 feet by 80 feet, my lords. The respondent, my lords, purchased the main land, and with regard to the marginal land, an agreement was entered into. That marginal land, my lords, a sale deed had to be obtained from the Bangalore Development Authority. After obtaining that marginal land in my name, I had to convey the property to them. My lords, I received a sum of rupees 1 crore as an earnest money deposit from the respondent under the agreement, my lord. Now, my lords, there was pursuant to this agreement, a litigation ensued in respect of this marginal land, and therefore, my lords, I was unable to convey this in favor of the respondent. Now, my lords, this amount of earnest money of 1 crore that I have received, my lords, must be refunded by me, my lords. I do concede there. Now, my lords, there were 3 important clauses, my lords, in the agreement, stipulating, my lords, what should happen in the event of a litigation ensuing. Whether, my lords, I need to pay interest on this amount that I have received.
How much interest granted?
My lords, now, my lords, the trial court has granted 18% interest.
Yes, that's the only issue now.
My lords, the issue, my lords, would be.
What do you say, ma'am?
My lord, the agreement itself stipulates 18%.
It does stipulate 18.
Please, my lord, agreement stipulates 18%. In fact, there were,
Is there any exception to that
my lord, it
in the
indicates
agreement?
that 18% interest could have, has to be in the event of deviation or breach of the agreement, 18% interest can be imposed, subject to an indemnity bond being executed by both the parties. It is their contention that there was no such indemnity bond which was executed, is their contention before the trial court. However, my lords, our contention was that they've admitted to having defaulted under the agreement. In fact, in a parallel suit, my lord, which they initiated to take possession over that subjected property, the court has held that they don't even have right title or interest over the property. Such being the case, my lord, they have executed this agreement to sell. I've remitted 1 crore on 2012-2016, my lord. And despite
Let's see the finding of the trial court.
Pass on the agreement, my lords, because.
We'll see that agreement. Let's see the finding.
Finding, my lords, may kindly take page.
Must have argued this before the trial court also.
Let's
see what is the finding.
Page 43, my lords. Page 43, paragraph 19, my lords, may I read?
Page 42, para 17 would also be relevant, my lords.
Which page you said?
Page 40.
Page 43, I said, my learned friend wants me to read from 42, my lords, paragraph 17.
Please, my lords. From the,
Yeah, read it.
may I read, my lords? From the above observations made in the judgment, which as on today having reached finality, it is abundantly clear that the defendant neither had the title nor possession over the suit schedule marginal land. And it is abundantly clear that the defendant has misrepresented the plaintiff that he is having possession over the schedule marginal land. In fact, the sale deed which is produced at Exhibit D5 nowhere speaks about possession of the marginal land being handed over to the defendant by the BDA. Existence of the property by BWSSB abutting the marginal lands is categorically brought out in the evidence of DW1 in his cross-examination. Therefore, it can be held without hesitation that as on date of entering into the agreement of sale, dated 2012-2016, the defendant neither had title nor possession over the marginal land, and therefore it is the defendant who has committed breach of the condition of the agreement of sale. Having observed that the defendant has breached the conditions of the agreement of sale, as per clause 28 of the agreement, the defendant is liable to refund the advance sale consideration with interest at 18% per annum.
What we say?
My lords, may I just pass on the agreement, my lords? My lords, the agreement, my lords, contains 3 clauses, my lords, regarding refund of the money. Regarding refund of the money, there are 3 situations also, my lords, contemplated. That, my lords, are, kindly see, my lords, the agreement. May I read clause 28, my lords? Clause 28, my lords, is at page 21, my lords, that's a running page, in page 21. You have the agreement on the copy. May I read clause 28, my lords? Whereas the purchaser has accepted the said offer made by the vendor for the offered sale price and agreed to purchase the scheduled property subject to execution of indemnity bond by the vendor undertaking to refund the advance amount paid during along with cost and expenditure with interest at 18% per annum in the case of litigation accrues or arising under the after execution of the agreement. My lords, this clause, my lords, is found before the terms and conditions, my lords, that follows. That is the next subclause 2. Now, my lords, in the case any litigation accrues, my lords, there was an understanding, my lords, that I need to execute an indemnity bond in their favor. My lords, no such indemnity bond has come into picture. This is one of the clause. My lords, there's 2 other clauses also, my lords, situated.
Case any litigation accrues between the parties?
Correct. No litigation in sense, but it's this clause on. Correct.
After the accusal, after the execution of the sale.
Correct, my lords. My lords, I have no problem, my lords, in reading of this clause. My lords, my only thing is that there must have been an indemnity bond entered into between us, wherein, my lords, we captured what are the situations under which I would be liable to pay this 18%. Why I say this, my lords, we have 2 other clauses here. There is one more important clause, my lord, which says, in the event, my lords, I am unable to sell this property, a liquidated damage, my lords, is already contemplated under this agreement itself. It says, my lords, I have to pay them 10 lakhs as liquidated damages. Now, my lords, if an agreement contemplates payment of a liquidated damage under section 74, my lords, do I have to pay, my lords, interest also? Is the only point, my lords, urged before the trial court also. Now, my lords, that clause your lordship would find at subclause 14, my lords, Roman 14, in the internal page at 28, my lords. Now, my lords, if the vendor fails, lordship gets it. If the vendor fails or neglects to perform his part of the contract, he shall pay a sum of rupees 10 lakhs as liquidated damages along with the amount paid under this agreement to the purchaser. Now, my lords, this clause, my lords, is found in the agreement which quantifies the liquidated damages. And, my lords, one other clause is also there, which my lords would find at page internal, that is the internal page 24, my lords, is clause 2.
Please, ma'am. Please, my lords. In fact, my lords, at page 24, I am entitled to 2% interest per month, my lords, on the advance consideration. At page 24, clause 3, subclause 2, my lords. If I may read, my lords, the vendor shall get the sale deed registered. Please, my lords. This was rejected, my lords.
Can't be both.
Please, my lords.
3% damages and 2%.
Please, my lords. Please.
He has done is pendant like he has given 18%. So what we are putting into is, once damages have been given, then you be entitled to pendant like interest. Maybe future interest we can think of.
Please.
There be pendant like.
My lords, I'm entitled to pendant light interest as well in view of the terms of the agreement itself, my lords, wherein it indicates that for every month's delay, I'm entitled to some interest. That was the agreement reached between the parties, my lords. Such being the case, now whether it is 2% per month or 18% as was agreed in the event of any litigation, here, my lords, I've repeatedly made a claim since the date of cause of action. The agreement, my lords, as per the agreement, the sale deed was to be executed before 31/1/2017. Further, through a letter, we had agreed to execute the sale deed prior to 36/2017, my lords. In view of their repeated requests, I had agreed. Suit, my lords, is filed on 8/10/2020. And hence interest is computed from 8/10/2020, my lords. And their conduct, my lords, in fact, the suit was, my lord, the breach has taken place. My lord, please, my lords. Please.
Before you file the suit.
Please, my lords, the breach has taken place as on 36/2017 itself. Please, my lords.
He had given you then.
There is no question
of possible damages, we can't say so. But he could have still given you damages because of the breach. Because of the breach, only damages are payable.
Please, my lords.
So before in 2020, when you file the suit, you would still be entitled to damages. Possibly it can be that. It can be your case. At breach, I am entitled to damages in terms of the stipulation.
Please, my lords.
That damages were payable on the date of breach.
Please, my lords.
Was to give 1 crore and 10 lakhs or whatever.
Please, my lords. Please.
Whatever is the damages.
Please.
Failure to give. What has been done by the trial court is from the date of filing of the suit, pendant light has been given not for the pre-suit.
Please, my lords, please.
And how would you answer this? How would you answer this?
My lords.
He has not given pre-suit interest. What has been given is pendant light and possibly future interest.
My lords, that interest, my lords, is at 18%, my lords. I would be satisfied, my lords, it's the national, the interest as charged by the National Bank, my lords. I will pay them that money. My lords, the stipulation, my lords, in the agreement is.
29 Central.
Yes, my lords.
You say you not execute.
No, my lords, they didn't insist, I didn't do it. My lords, it's a part of the term. My lords, therefore, what I'm saying is, there are three different clauses here. Now, my lords, the final clause, my lords, found here is, it's the liquidated damage, my lords.
You did not execute because there was an 18%.
No, my lords, that's not the thing. They didn't insist also. Let them show any document, my lords, where they insisted me to do that.
Once you have agreed,
My lords,
be a reiteration of everything.
no, my lords, I'm not on that point. My lords, now, I'm only on the point, my lords, that once a liquidated damage is quantified without interest, and the quantification is at 10%, 10 lakhs, whether, my lords, I need to pay interest on that.
Scale of damages has been decided another 20 years thereafter. You would still say it would be 10 lakhs only.
That's the contract, my lords.
Contract is also 18%. So
No.
meaningfully read, what we are putting it, we will not elicit your reply on this. Breach, on the date of breach, you would say there is a breach, here is your 1 crore, here is your 10 lakhs damages. That's the end of it.
My lords, here this is an unfortunate case. What happened here, my lords, is I didn't purchase this property from per private person. My lords, the property that was belonging to me, which is the main land, abutting the main road, was about 80 feet by 120 feet, my lords. Now, there was a marginal land, my lords, belonging to the Bangalore Development Authority. That marginal land, my lords, abuts to this property, which is behind this property. My lords, and he purchased the main land from me. Since there was a marginal land behind that, they insisted, my lords, I obtained a sale deed from Bangalore Development Authority. My lords, because they insisted, we got into an agreement. I went to Bangalore Development Authority and said, please give me the marginal land. Bangalore Development Authority executed the marginal land sale deed in my favor. That land, my lords, the BWSSB claimed that it belongs to them. My lords, I have not done anything wrong in this case at all. No matter what happened was, it's very unfortunate.
So far, I think what the trial court has said, that's what we are putting it in. On the date of breach, if you were to say that this is the date of breach, I have to give you 1 crore, and there is a quantum of damages which have been specified. These are the damages. So your interest liability would stop.
Therefore, my lords, 2018, my lords, 2018 is the first time when they write a letter to me saying that since there is a litigation in this property, you please refund the money. My lords, my reply is that I have filed a suit for against the BWSSB, claiming that I am the owner. In the event I succeed, I will execute the sale deed. My lords, therefore, my lords, they did not also institute a suit till 2020, my lords, because they were also awaiting the decision of the suit that I had filed. Unfortunately, my lord, my suit was dismissed. Pursuant to my lords, in fact, I have instructed my client. Therefore, from 2018, my lords, I would be liable to pay 1 crore and 10 lakhs according to.
Now, the document prior to the filing of the suit.
No, my lords.
Say post-suit.
Correct.
There was an option for you. Look here, there is damages and 1 crore, I am paying it. Liability stops. 20 and this decrease which year?
24 minutes.
24.
Please, Manoj.
So that suit continued.
Correct.
Okay, if you had given it on the first day, when they filed the suit, when your suit was dismissed, they would not have any liability.
My lords, it is common evidence, my lords, that even now they are ready to take it from me. They are saying.
You say on the submission, interest which is payable, how much would be? Is there any likelihood you can agree for a likelihood?
My lords, repeatedly, even during the suit, my lords, pre-initiation mediation, they don't show up, my lords. It was in the nature of a summary suit which the suit was filed. Thereafter, the Honorable Trial Court said, we'll hear it as a regular suit. They don't file their written statement, my lords. For more than a year, written statement is not filed. Such being the case, my lord, repeatedly we've had mediation sessions. Despite admitted liability, their only intention was to unjustly enrich themselves and defraud the parties. Further, my lords, that suit where BWSSB is declared to be in possession, they have not even challenged that order, my lords. They kept assuring me that we'll give you the land, and they did not even challenge that judgment.
Suit which had gone against them.
Please, my lords.
Tell us one thing. What now you are saying? And the order also reflects, you can see that 1 crore is.
No, I concede, my lords, I have to pay.
concede on the first day itself when the suit was filed.
My lords, because, my lords, there's still, the negotiation was still on. My lords, my lords, I concede, my lords, that I need to pay them interest, my lords, it's not, I don't have.
Doesn't go beyond that.
My lords, only thing is, my lords, 18% is very exorbitant. My lords, that clause, my lords, would not come in. My lords, but 18% would be very. 18%.
My lord is saying that to the extent of 2%, you succeeded.
My lords, that's true, my lords, but 18%, my lords, is very high. My lords, unfortunate situation here, my lords, is, my lords, I have deposited 50 lakhs, my lords, also. Yes, my lords.
That was a condition for their written statement to be taken on record, my
I
lord.
have deposited.
They challenged the order before the Honorable High Court. Thereafter, 1 crore deposit was modified to 50 lakhs.
My lords, the interest may kindly be reduced to some extent, my lords, because, my lords, the 18% will.
What is wrong with the justification?
My lords, what is wrong according to me, my lords, that 18% contemplation, that is clause 28, would not come into picture, my lords, because.
Obligation was on you to execute the indemnity. You don't execute it. Now you are taking the plea that since there is no indemnity bond, 18% is not paid. You're getting the point.
My lords, that's not the only thing, my lords, but there are 3 other clauses, my lords, and the final clause, my lords, is quantification of the liquidated damages. My lords, liquidated damage is also, my lords, liquidated damage is also given, and 18% is also given.
Let's put it rephrase ourselves. The moment there is a breach, 2 things follows. You will give the amount of 1 crore and you will give the damages. So there is a breach. You don't give it. Till 17 to 20. 20 they come to the court. And resulted in a decree in 24. Now, for you to say that once damages have been in, if you were to, the damages were payable on 2017. Period thereafter till the decree, would you not be entitled to pay interest even on the damages? That has not been granted, that's a different issue.
But not at 18% is, that's all, my lords.
Now, how would you come out of this 18%?
My lords, this clause, my lords, is not applicable.
So their claim was from 2016.
Correct.
For interest is from 28/12/16.
Correct.
The equity, there is a contract which is staring at us. There is no contract, discretion is with the court, we leave it.
My lords, but the unfortunate thing, my lords, is,
54% also, merely because there is a stipulation.
my lords, my unfortunate thing, my lords, is that at their instance, my lords, I went and got the marginal land. And my lords, marginal land, my lords, it's not as if, my lords, I was holding. I got it from the Bangalore Development Authority, my lords. And therefore, my lords, now,
The extent of interest not granted for the pre-suit period, you have said. That's the same. Just take the challenge with this, the finally disposing of after you see the solutions. No decisions have been made by the legal counsel for the appellant on the grant of liquidated damages. The amount of rupees 10 lakhs to the respondent herein. Since this issue which was of arbitration on grant of interest at the 18% the amount of clauses of this 28.
Roman 3, small 2 minutes.
Clause 3, subclause 2.
And also, which is the other clause?
My lord, clause 3, subclause 2, my lord. It's at page 24 of the agreement.
Clause 2 at page 54 and subclause 14 at 23. That once the to content that in view of the breach as the to content that in terms of clause 28, the amount of 18% interest is payable in the eventuality any indemnity bond has been executed by the appellant herein. And as no such indemnity bond was executed, instead amount of interest is not payable. The interest of 18% per annum is not payable. That the party is in submission that when the agreement between the parties contemplate in the eventuality that the appellant reflects perform this part of the contract on my completion, pay an amount of 10 lakhs as liquidated damages on a grant of 10% plus 18% per annum interest at the rate of 18% per annum. These totally untenable. The High Court has by granting interest at the rate of 18% per annum as stated as in paragraph 15. Of 15% each only from the date of suit till realization. There were the tribunal that not granted pre-suit interest in favor of this common period. So the considered position that the breach of agreement had taken place when
36/20/17, my lords.
36/2017.
17. Please.
The suit was filed in the year 2020.
Please.
And it was agreed in the year 2024. It is the submission of the legal counsel for the respondent that during the pendency of the suit, no attempt was made by the appellant to refund the amount of 1 crore to the respondent. Even that part, even the parties that are despite the parties relegated to the mediation process. No such stand was taken by the appellant. It is because of the fact that the amount was not paid by the appellant. Paid by the appellant, that the trial court, having justified the claim made by the respondent, has decreed the suit in the manner it has done. Full stop. Having heard the learned counsel for the parties and he had to learn and peruse the provisions and peruse the contents of the agreement on which reliance has been paid by the learned counsel for the applicant, and also noting the justification given by the trial court for granting the interest in the manner it has done in the impugned judgment. We are of the view that the impugned judgment will be insofar as the limited challenge to the interest aspect is concerned, cannot be interfered with. Cannot be interfered with. We cannot in the appeal, saying this is.
Great. 30.
Yes.
My lord, sir,
No, the writ petitioner.
I appear for the appellant in 30.5, my lords, and I appear for the corporation. We have engaged services of senior counsel, my lords, and there's some difficulty today. He's not in town. Therefore, my lords, issue is regarding my lords seniority and my lords.
My lords.
Yes,
no,
my lords, my lords.
I had heard only the gist of the issue, my lords. My lords, one humble request, my lords. My lords, on the last date of hearing as well, same submission was made and time was sought, my lords. Finally, let them, my lords, somebody make amends, my lords. There are a battery of advocates.
Very well. Very well.
First matter, but we apply.
They say that at the request of you also make a similar request?
Lord, in serial number 30.4, but that may not be, Lord, connected to the, Lord, the other appeals. Lord, that is pertaining to, Lord, promotion. Lord, I had approached the learned single judge seeking for a direction to consider my case for promotion, where, my lord, the penalty was set aside by this honorable court in respect of one inquiry. In respect of another inquiry, there is an interim order. Therefore, my lord,
Yes, 30.4, my lords, the entire issue is with respect to appointment by transfer candidates. Now, this respondent in 30.4 also falls in the same category of an appointment by transfer. Now, if his right to appointment by transfer is denied in my appeal in 30.5, he is also the respondent in 30.5. Therefore, my lords, it's all, the consequential relief will not survive then. My lords, he's not in station, my lords.
Four, 6.
Great.
Great.
Your lordships, I appear for appellant in this case, your lordships. I pray for a short accommodation, my lord. Senior is indisposed, my lords.
Appearing for the state, my lord.
Milords, in this matter, Milords, the third respondent had calculated the difference amount of gratuity at rupees 1,11,178, Milords, and also the interest at the rate of 10% of rupees 56,364, Milords. The corporation, the third respondent, the corporation, Milords, that is respondent number 1, feeling aggrieved by the order dated 16/3/2018, Milords, passed by the Assistant Labour Commissioner and Controlling Authority, Davangere District, under the Payment of Gratuity Act, filed appeal before the Assistant Labour Commissioner, Milords, and the Appellate Authority, Bellary Division, under the Payment of Gratuity Act. The second respondent, by order dated 4/4/2019, Milords, dismissed the appeal filed by the respondent number 1, Milords, that is the corporation, Milords. The corporation has not calculated the gratuity for the non-working period of 4 years, 1 month, Milords, and the corporation has not passed any specific orders, Milords, showing the break in service for the said period, Milords. The appellant filed application claiming the difference on 21/2/2013, Milords, and there is a delay. And there's a delay of 14 years in submitting the application, and the learned single judge allowed the writ petition on the ground of delay and laches, Milords, by quashing the order dated 16/3/2018.
Was there any break in service?
There was a break in service, Milords.
When was that?
Milords, senior will come and argue this matter, Milords. Short.
This is a small matter. We'll not just call your senior. We are passing it over.
Milords is indisposed, Milords. The matter may be kindly passed over, Milords. I'll submit my argument.
We'll pass over the matter.
Yes, Milords.
Para 7,
Yes.
32, Shivjay Kumar. For the respondent 2 and 3, Milord.
Appellant.
For the 32, for the respondent number 2 in this matter.
Yes. For appellant, sir.
32.
32. Some confusion.
Yes.
Appellant. As per the single judge order, we are complaining that, order of the single judge. Violation of portion, we are removing that. In the third floor, we are remove the entire construction. We will apply that modified plan and we will, after that. Appellant.
He is the, my lord. He was the petitioner before. Yes, ma'am. Leelavati, yes, ma'am. Yes, ma'am.
The subject matter of the challenge without any obtaining any permission, respondent number 2 has made the
Construction of the residential house. Neighboring, my lord, filed the.
for damages, everything.
Yes, ma'am.
And what ultimately the single judge says, so please.
Lord, the learned single judge has pointed out that the residential house is, my lord, completely violated and it is without, my lord, license.
Must go.
It must go.
Challenge.
Sir, we are modifying that. We are doing it with third floor, we already demolished. We are applying the sanction plan for alternatives. We have. First floor and second floor, we have to try to construct a pillar for supporting building. Violation portion, we have to demolish that. Structuring, sir, removing that violation of that. You have applied the modified function plan once again with the corporation. Applying that.
3 months. Okay, as the structure stands, it's not as per the sanction plan. Are we right?
Yes.
So you will bring it in accordance with sanction plan.
So that's why we have to apply the modified plan to from.
Sanction plan which has been approved
Okay.
to you, given to you, is as per the bylaw. They can't change the modified, the sanction plan.
Because we have construction 2 floor, or this is the.
Lord, may I make submission, my lord? I am representing on behalf of the respondent 1. I'm for the municipal authority, my lord, local body authority.
Oh.
Application ಹಾಕಿಲ್ಲ application ಹಾಕಿಲ್ಲ ಹಾಗೆ no application filed. No.
Who appears for this petitioner?
I appear for the petition, respondent number 2, my lords. My lords, please, my lords, I am the neighbor. I had given the complaint to the municipality actually saying that. No, my lords, no. That the same has been recorded in the single judge order, my lords.
Standing as it is.
As my lords, standing as it is. And there's a complete violation of 64.65%. My lords, as per the act, it says that if there's a violation up to 50%, then in a residential property, you can give concession. But
160.
they have crossed in each floor, they've crossed more than 50.
So,
My lord, up to 50%, my lord, we can regularize under section 187 of A of the, my lord, Town Municipalities Act. It is above, my lord, 200% of. Then he is the advocate. The complainant is the advocate. We made best highest attempt to settle the issues, my lord. Even learned single judge also, my lord, call it to the chamber and my lord arranged everything for settlement with respect to the trying to not to demolish the, my lord, building, but it has not happened. Then continually, my lord, the litigation, my lord, overcome before the court. Then ultimately court has come to this saying that it is impossible to continue because mason work not completed. Without pillar, the structure has developed. There is a dangers to the house of the, my lord, that is complainant, neighbor, who is the advocate. And my lord, these all the things has been developed, my lord. I also made my best effort with respect to the settlement by removing 1 floor. And they agreed, but he has never agreed. And he told that no, as per the license only it. Plan, no.
explicitly it is not.
No.
So what is wrong with the other single judge judgment? We want to know.
Kindly pass over some. Senior will come. Kindly pass over matter. Senior will. Come on.
Come on.
2 more. Interim order extension.
Interim order extension.
Much.
33. Vijay Kumar.
I appear for the
In the government.
appellant in this matter. It's yesterday's matter, my lord. There is some difficulty, my lords. The arguing counsel is not in station.
Where is the boy? Where is,
He's
where is the gentleman? Come, you will argue. If that's the promise, they should be on that promise. So you will argue. Okay. Just leave it, let it. We will not be saying, dismiss it. Who is the senior? We want to know.
Lords.
Yesterday, a request was made for
Lord,
senior. Today, you are making a request.
no, my
for
lord.
senior.
I'm senior to him, my lord, but I have a senior, my lord. His name is Vijay Kumar Bajantri. Yes.
So you have to.
Yes. My lord, the learned single judge, my lord, dismissed the writ petition on the ground of delay and laches. The delay and latches does not arise at all, my lords. Kindly see the prayer made in the writ petition, my lords. Page 32, my lords. My submission before lordship says the petitioner, Lord, is not claiming any promotion here. He's claiming for change of cadre. He's not claiming any promotions, my lord. He is claiming for change of cadre as per the regulations prevailing. Lord, kindly come to page 32, my lords. Lord, I have represented on 24/8/2012. Lord, they slept over the request. Writ petition filed in 2021 because cause of action arose only in the year 2021. Lord, the seniority list is published in 2021. That is what I am pointing it, Lord. Please, Lord. Yes, my lord. They effected in 2015. No, 2015, my lords. I requested for 2012. They did not do it, my lords. Till 2015, my lord. Thereafter, my lord, I kept representing them. I was under the impression, my lord, that the authority will consider. My lord, I bow down to your lordship's observation. Lord, kindly, Lord, there were no seniority lists published till 2021. Lord, they have to, Lord, until and unless, Lord, where I am placed in the seniority list, Lord, how can I, Lord, where is the cause of action for me to approach the court?
So you are not challenging the change of cadre.
Change of cadre is also questioned, Lord. Yes, Lord. Yes, Lord.
Seniority depends on the change of cadre.
Please, Lord. Lord,
29/8/2015,
29/8/2015.
Then page 145.
Lord, for a moment, Lord, may I request, Lord, kindly come to. Yes, Lord.
29/8/2015.
That's the time.
Yes, Lord.
On your own request.
Lord, I made a representation. To that representation, they have endorsed in 2021. Then only, Lord, I agree. 24/8/2012. Yes. 15. Saying that, my lord. No, my lord. I did not. They have given me, effected the change of cadre in 2015. I have taken it, my lord, but I did not. My lord, I accepted it because, my lord, I have to, my lord. Otherwise, my lord, what has happened here? I am appointed in 1988. Thereafter, my lords, in the year 1993, my lords, I was given promotion to the post of assistant engineer. In 2007, my lords, I was given promotion assistant executive engineer, non-graduate cadre. During the service, my lord, I have acquired the qualification of bachelor's in engineering. In 2012, my lords, I immediately make representation as per the prevailing rules, my lords, of 2007. I made representation on 24/8/2012. There were no inquiries pending against me, my lords. The charge memo was issued, which was withdrawn by themselves. But as on the date of representation, there were no charge memo or no inquiry was pending against me. They slept over the file, my lords, holding that the inquiry is pending, and he considered my claim for change of cadre in 2015. There were no, please, my lord. My lord, thereafter, my lord, after granting me change of cadre, my lord, I made a representation stating that it has to be effected from the date of making representation. 24/8/2007. What? Lord. Change of cadre, Lord. As after completion of Lord, question, Lord, I made a representation requesting them to consider my until and unless, Lord, there is some order to Lord to Lord. No, Lord, I requested the authority, Lord. I am an employee of the corporation, Lord. I have to make a request. Without there being any request, Lord, they will not consider. First, I made a representation, Lord. Thereafter, Lord, I waited for some time. Lord, they did not consider it, Lord, till 2021. The seniority list is only published in 2021. And thereafter, Lord, I came to know where I have been placed. Lord, thereafter, on the very same day, Lord, they have issued an endorsement.
We can hear you with this.
Please, Lord.
That even the seniority list which they have issued is not in accordance with your change of cadre. Means change of cadre having taken place in 2015, the persons who have come later in the cadre have been shown above you. That's the only ground. And that is not your case.
That is not my case, my lord. That is not my case. My case is only with regard to, my lord, non-considering or delaying the process of considering my claim for change of CADA. That was the request made by, for the authority. That they have not considered till 2015. Lord, thereafter I made a please, my lord. Order change of CADA, my lord.
147 is the typed copy, my lord. Translated copy, I'm sorry. My lord, in the order at page 147, it is very clear that this, if I may read out, my lord, the last two lines, his seniority has been fixed at page 146 and 147. After the position to the next of very junior in the assistant executive engineer graduate cadre to the date of issuance. Lord, he submitted objections to the seniority list. We issued an endorsement
Then
rejecting
only
his
cause of
objections.
action arose to me.
Lord, the draft seniority list, my lord, 27/8/2021, my lord.
Lord, that
And
is
my
not the
lord,
thing, my
even
lord.
the-
Lord, whether the claim made by the petitioner is, where appellant is legitimate or not, that they have to decide it within a time, Lord. They kept waiting for 3 long years, my lord. They did not consider.
that is not
Thereafter
right.
only, my lord, I have made a representation. When they have given,
Especially in 2015, when they have expressed themselves.
I have made a representation in 2015 also, my lord.
That's all. That stop. You stopped at that. You did not come to the court.
Lord, there was no response to my representation, my lord. That is the reason, my lord. That is why, my lord, they have issued endorsement in 2021, my lord, throughout, my lord, the seniority list, my lord, which was published in 2021. May I make one request, my lord? The issue, my lord, 2021, because the seniority list, my lord, which was the pending consideration before the Honorable Supreme Court in BK Pavitra's case, my lord, that is the reason, my lord, there is a delay in publishing the seniority list. I do agree, my lord. But the thing is, my lord, the claim made by the petitioner, that is in accordance with the rules, my lord. What the rule says, my lord, they have to consider immediately.
They have expressed themselves, your seniority position would be before the next immediate year. Simple. Say so. You should have contested, look here, my seniority must relate back to 2012. Not before the immediate union.
I made a representation that endorsement says, endorsement is issued to. Lord, the representation is with regard to, my lord, considering my claim for, my lord, from the date of, my lord, acquiring the qualification. My lord, I have challenged the order of that prayer may kindly be seen, my lord. That also I have challenged, my lord. For a moment, my lord. Lord, for a moment, Lord, in the writ petition, I have challenged the change of cadre granted to me. That is also challenged, Lord, page 32. Lord, until and unless, Lord, some, Lord, the representation, Lord, they have not responded, they slept over the file, Lord.
They have not even given it 2020. They will give you 2013. You will say we will get a follow-up action then. By the time you have retired. That argument would not gel.
Lord, I do, Lord, immediate, Lord,
And most of seniority issue, most of change of cadre. You know, one person changing cadre from one place to other, third party rights gets affected. Suppose I am in one cadre, my lord is in another cadre. My lord comes to this.
my claim is that only, Lord. So many people have gone above me because I got promoted to the post of assistant executive non-graduate in 2007. Lord. Till today, I'm discharging as assistant executive engineer only. That is the, Lord, the illegality, Lord.
Prejudice.
Yes, that is the prejudice, Lord. That really, please, Lord.
We'll tell you why. Today you are challenging the change of cadre. How many people who have also been allowed change of cadre will follow you? Only on this ground that our seniority has been downgraded. We are at the very bottom. We are not getting promotion. Everything will go.
The rule, Lord, what it says is, Lord, from the issuance of the order of change of cadre. That, Lord, they have delayed, Lord. I have not. It is not a an error committed by the appellant or petitioner, my lord. The authority, my lord, slept over the file.
Please.
Let's assume overlook that.
There was no department inquiry was pending.
Let's for a moment, let's overlook that plea.
Please.
Fact remains, in 2015, when you were allowed the change of cadre, you were allowed the change of cadre without stating it must relate back to 2012. They don't say so.
Yes.
They also say so. Your seniority would be just about the next below junior.
Yes, sir.
So there were two things which you would have said. Yeah. It should relate back to 2012, and my seniority must also relate back to 2012.
Yes, my lord. That was, yes.
That's the point.
No, but they.
Between 2015 and 2020, third party rights would have come. People have got, the benefit of some other service condition.
The corporation has many posts vacant, my lord.
You say nothing.
Lord,
On the basis of that seniority.
clear case, my lord. Please, clear case, let there be an observation with regard to, my lord, making, liberty may be reserved, my lords, to make representation to the corporation, my lord, to consider in respect of granting the change of cadre with effect from 2012. Lord, that is the claim, my lord, that if that is.
That is the issue.
Lord, I will not get any promotion hereafter, my lord, because there are more than 500 people above me. Now, my lord, I'll be retiring without any promotions, my lord. From 2007 to 2000, another 2 years, 3 years service is left for me. Yes, okay, 10/7/2012.
The respondents have issued a draft seniority notice to which the appellate hearing had 5 objections. Those objections were decided and communicated to the respondent, that will be appellate hearing on
27/8/2021.
which date?
27/8/2021.
7/8/2021. This order, it was challenged before the learners' illegal.
Please, endorsement.
It was challenged by before the learners' illegal. We have already reproduced the conclusion drawn by the learners' illegal. Paragraph. We have already reproduced the relevant conclusion drawn by the learners' illegal. The conclusion drawn by the learners' illegal are: 1, the appellant had sought to change of cadre, which was decided only on 29/8/2015. 2, the appellant had not challenged either the change of cadre must relate back to the year 2012, or he has challenged the stipulation in the order dated 29/8/2015 that his seniority is fixed after the position to the next of very junior in the assistant executive bracket graduate cadre. Full stop. Because only And the last seniority list was issued, to which representation was made, and the said representation was rejected, when the petitioner, the appellant had approached the court by way of the petition.
After the final.
Publication of final seniority list.
After the petition,
And
After the
publication.
final, publishing this final,
Seniority list,
27/8/21 minutes.
27/8/21.
7/8/21.
Then only the call.
So we agree with the facts, we agree with the conclusion drawn by the Secretary. As much as the petitioner having not challenged the change of order from 2012 and also not contested the seniority position which was assigned to him in the order dated 29/8/2015. The petition that was filed before the Secretary was hit by delay and lapse. So we could not do it.
Liberty may be not reserved to make a representation to the corporation. Let them consider, my lords, if, but what has happened is, my lords, in the, I don't have the material to show, my lords, on 10th of July 2012, juniors of the appellants, my lords, have been considered for change of CADA. Lord, only, my lord, with regard to, my lord, there was an inquiry pending. There was no inquiry pending so far, my lord. That, my lord, due
But
to that
that
only, my lord, they have delayed my change of CADA.
Penalty order is imposed.
That is,
Penalty order is
penalty
imposed.
order is imposed, but as on the date of, my lords, my representation, there were no articles of, the charge memos was not issued. Lord, my juniors were given change of CADA on 10/7/2012 itself, my lord.
Kindly pass over senior engagement. Yes.
Respond number 5. Respond number 5. Kindly date fix.
Its interim order may be extended. Great.
35, 14%.
Appear for Arthe Malad, kindly pass for me. Senior.
This is the matter regarding the maintainability and
35. Malad.
35, my lord. 2 FIRs.
You appear for whom?
R3, my lord.
You appear for
R3.
R3. Have it next week. Okay?
Okay.
My lord, after 2 weeks, if it can accommodate after 2 weeks, on 13 and 14, sir, one Israel delegation is visiting here, and we have to discuss one defense deal with them on 13, 14, except that any other date. My lord, 10th, 10th. My lord, 10th.
Yes.
10th.
My lord, 13, 14 senior out of station.
10th.
Seventeen, 3.
17.
Obliged, man.
36.
Lord, for the petitioner.
Lord, I've been requested to, my lord, I've been requested to
appear in this matter, my lord, I'll need some time to go through it. We have challenged the order of the tribunal. Publication, my lord.
12-6.
Much obliged, please.
37. Basuraj. 37.
I am for the petitioner, my lordship.
For the respondent. I am for the respondent.
Sir, the petition is already, the respondent is already out of service now. WP has become an infractus. Our learner friend will put up a memo for that.
He was relieved from the duties on 27th February, compulsorily retired. Therefore, this writ petition, yes,
Compulsory retired out. Compulsory retired out, premature retirement under Part 56J. Yes. No. My lordship, we will put up a memo. We are not sure it, but our advocate is telling, our friend is telling, I will put up a memo, my lordship. Yes.
sir, we can file it.
Very clear.
Yes.
It must not come from you, it must come from him. He is the petitioner.
Okay.
Who is the petitioner?
I am the petitioner, my lordship.
It must come from you.
Yes, my lordship. Yes, my lord. Next date, the 2 weeks time, please. Yes, my lordship.
12-3. 12-3. 38 urgent. 39 Rajesh Kumar.
My lord, this is the matter which on the last date, my learned friend, I have disobeyed my lord's orders, my lord. I have disobeyed my lord's order. I have not filed this synopsis, my lord. I require a short accommodation. And I'm also intimidated by the synopsis which the other side has given last night, my lord. Runs to about 900 pages. So, my lord, I am intimidated and I am in contempt, my lord. Therefore, that's what I told him, my lord, jokingly saying that, my lord, I'll request the court to reject it by saying it is not a synopsis, it is a thesis. That is the nature of his appeal, man. That is the nature of his appeal. Yes. My lord, could it be next week, my lord?
10 days
My lord,
time.
the reason is, my lord, they have not deposited any money before the trial court or before this one. My lord, I'll take around 45 minutes to an hour. 45 minutes. 37.
But 10 days time.
28th. Grateful.
28.
Well.
Forty and 41 adjourned, 42 government advocate, 42.
This is a case, my lord, where sub-registrar had declined. This is a case where sub-registrar had declined to register the document, my lord, on the ground that Lebanese sketch was not produced. My lord, my instructions are that, my lord, issue is pending before Apex Court, my lord. Yes, my lord. Tentative, next date is 17/3, my lord, there. Obliged.
43, Sri Gangadharappa.
For the appellant in this matter, my lords, I seek for pass on. Pass on. Yes, my lords.
Eleven six. First door matter 6/4.
ST matter, my lord. This ST matter, my lord. They said that, my lord, the SLP is filed. Even, but I just found out that an SLP is filed, my lord. Manjula versus Deputy Commissioner. Lord, the diary number is there, my lord. It is. It is filed on 24/2/25, my lord. Petition, internet. Please, my lord. Yes. Against that, they have preferred this. Please, my lord.
Serial number 11. 11, Vishwanath. Serial number 11.
Lord, this is serial number 4, my lord. He's come. Yes, ma'am, that is what I told him.
Please.
Serial number 11. Number 12, Shri Sachin BS.
Your lordship, I appear for respondent. This is TDR matter, your lordship, we are ready, your lordship. This is the matter wherein your lordship, they have, your lordship, they have utilized my land for the purpose of formation of road, your lordship. Then your lordship, they have, the BBMP recommended to issue TDR. But the BDA, your lordship, they say that your lordship, because in terms of the section 14 of the Town and Country Planning Act, I am not entitled for the TDR. And
All grantees claim grantees, my lord, the grant certificate.
that's a transferable development right in
Section 70-14 of the Karnataka Town and Country Planning. What transpires, please do not see. If there is for the purposes of formation of a road, some portion is required, please, my lord. We will acquire the road portion and instead of, my lord, compensation, we give them transferable development. Is to say, notional land is given to them in the nature of a certificate. Where will they use those? They will use it, my lord, to build it up vertically. Well, construct more, they get more FAR, so they can go up. In their own program, in the very same problem. That is the logic behind it. That's a transferable development of right. That is saleable, please.
Your lordship.
Of the Karnataka town.
because your lordship, they, in fact, they utilized, there is no dispute that they have utilized my land. Thereafter, they have shifted me to another survey number. That survey number, your lordship, that in fact, that is, BDA has acquired for the purpose of the formation of layout. Thereafter, though they have issued Hakupatras in my favor, your lordship, they couldn't give the position of the land. Thereafter, finally,
Patras, my lord, two patras, what they are claiming. There, my lord, the officer who has included had the power to have issued. He does not even have the power to have issued it. The Tahsildar could not have issued it. PDO will not, could not have issued it. Now, my lord, that property is not the property is belonging to the state. So now, my lord, they claim to be the owners of that property and we have to give, let's TDR to a state property.
Some short. 230 KPTC. So. Let's see, can I request this month, because any date if possible, Melody, this, so that.
Sir, 27-3.
May I request 2:30 on that day, please, subject to my lord's convenience, if it is possible. We want a quiet. Sorry, my lords.
Number 13.
SC matter. SC matter. SC matter pertains to SC 13. Please, ma'am.
14. Muralidhar.
and for the petitioner,
Some personal emergency, senior counsel unable to appear today. Kindly state after 2 weeks, madam.
Excise matter, my lord. Learned single judge has dismissed their writ petition.
It's a educational trust, my lord. It's nearby education school, the after 1 week time may be granted.
Respondent.
Private respondent.
Private respondent who is the licensee. The writ is against. Lords.
Hmm. 18-3, sir. Much obliged.
Obliged.
Seventeen. 17. Fine.
Hearing for appellant in this matter, the respondent. Let's request for short accommodation. Minutes. Senior is not available. Can it be posted on 13th minutes? Senior is not available. Senior is not available. Available is out of station. My apologies. But can it be taken up on 13th minutes?
12-6.
Manoj, if I request for a shorter date, Manoj. Manoj, on the previous date, I had undertaken not to initiate execution proceedings. If I may be permitted to initiate executing proceedings. Please, Manoj.
22-4.
Please, Manoj, I'm grateful.
31. 31. Where the move? Hearing for the state, my lord. Yes, my lord. The petitioner counsel wasn't there. The contesting respondent is the Karnataka State Road. Please.
My lords, in serial number 12, interim order may kindly be extended, my lords, because my lords, I was held up in quota number 16. I couldn't appear in the second round. Serial number 12, my lords. in a writ appeal, there is an interim order. Much obliged.
ಸರ್ ಬೆಂಗಳೂರು ಕೇಳಿಸ್ತಿದ್ಯಾ ವಾಯ್ಸ್?
ಸರ್ ಕೇಳುತ್ತೆ.
ಕೇಳಿಸ್ತಿದ್ಯಾ ಮೇಡಮ್? ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಲ್ಲ?
ಹೌದು ಮೇಡಮ್.
ಸಾಹೇಬ್ರು ಬರೋ ಒಂಚೂರು ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಸರ್.
ಹಾ ಹಾ.
As the fitness test, and the other good news is that they've kept them
ಸರ್ ಕೋಟಲ್ 2 ಇಂದ ಸಾವಿರ ಬರ್ತಾ ಇದ್ದಾರಾ? ಹಲೋ ಮೇಡಮ್ ಇಲ್ಲ ನೀವು ಅದು ಇಲ್ಲಿ ಸಾವಿರ ಇನ್ನೂ ಬಂದಿಲ್ಲ. ಅಲ್ಲ ಇಲ್ಲಿ ಈ ಸೀನಲ್ಲಿ ಬಂದಿಲ್ಲ ಸರ್. Sir, total to ಸಾವಿರ ಬಂತು ಬರ್ತಾ ಇದ್ದಾರೆ sir.
Hello. Good afternoon, brother.
Yes, my lord. Good afternoon.
For pronouncement, Bhushan.
We are of the view that the impugned order of the tribunal is liable to be set aside. We order accordingly. The petitioner shall be entitled to the benefit of great pay of 8,700 from the date of his promotion as senior architect on 5/11/2007 notionally. The actual benefit shall be paid from 1 year before the date of filing of the OA. The pay shall be fixed on notional basis with effect from 5/11/2007. The petitioner's pension and other benefits thereof shall also be refixed, and he be given the areas thereof within 8 weeks from the date of receipt of copy of this order.
ಬರ್ತಾ ಇದೀನಿ.
There's one matter, no? There's one matter remaining. It's called that.
Serial number 31.
Case, my lord. The appellant being highly aggrieved by the order dated 29/9/2023 passed by the learned single judge dismissing the writ petition, my lord. The present appeal is filed, my lord. The brief facts of the case are the appellant joined service of the corporation KSRTC on daily wage basis with effect from 28/10/1961, my lord. I was sort of brought on probation with effect from 29/3/1963, my lord. And he attained the age of superannuation on 31/8/1999, my lord. After retirement, the corporation was expected to calculate the gratuity entitled, and it should have been paid, my lord. But in this particular case, they have not taken into account 4 years, 8 months, 1 month and 8 days. They are breaking service on that. But
was there any break in service?
But corporation has not passed a specific order to that effect, my lord. In the absence of that, the continuity of service has to be considered. Corporation was expected to pass a specific order showing the break in service, but they have not done it.
No,
It is serious lapse.
We want to know whether there is a break in service.
Yes, my lord. 4 years, 1 month, 8 days. But there is no specific order by the corporation. Consequently,
One minute, we will see the effect thereof later.
Please, my lord.
When was the break in service?
Right now, but there is a break in service for 4 years, 1 month, 8 days, my lord.
Now, when did you join the corporation?
28/10/1961, my lord. And control one sufficient.
And break in service was?
In between, my lord, in between.
What is in between? What is the date?
detail is not available readily right now, my lord, but there is a break in
Not
service.
forthcoming from the records, my lord.
Pardon?
It's not forthcoming from the records, my lord. But in the,
Now, total 4 years of break in service.
Corporation was expected to pass an order. They have not done that.
No, we just want to know, when was the break in service? For how long was the break in service?
4
And-
years, 8 months, 1 month, 8 days.
So this is the break in service. So this period was not taken into consideration.
Not taken into consideration. But in the absence of,
Break in service in any case entail forfeiture of the service.
please, my lord, please, my lord.
So then how would you be entitled to?
Hello, in the absence of special order by the corporation, my
Doesn't
lord.
make any difference today. We are considering the issue.
And this aspect has been considered by the controlling authority as well as the first appellate authority, my lord. And they
It's
have
all right.
rejected the contention taken by the corporation.
But it's your own case. You are not disputing it, that there is a break in service. So if there is a break in service, there is a consequence.
But my humble submission, my lord, in the absence of special order by the corporation, that should not have been taken into account, my lord.
See, nothing would transpire. Nothing would really happen. It's inconsequential. You would not get the benefit when there is a break in service.
And the Honorable Apex Court in umpteen cases has said, has held, and if there is no specific order, the period has to be calculated. Right now, we don't have judgments, but if you
We
are not,
want to know, is there any specific order for break in service?
there are umpteen decisions by the Honorable Apex Court.
Pardon?
There are umpteen decisions by the Honorable Apex
No,
Court.
that decision will come later. We want to know, is there any break in service order with you?
There is no break in service order.
Then how are you saying there is a break in service?
my lord, if your lordship
It is the contention taken by the corporation, and there is no order to that effect.
Ma'am, what are your instructions?
my lord, if your lordship looks at page 40, that is the Court of Labor Officer, Annexure A. In that at page 43, if I may read that, wherein it looks into the break in service of the appellant herein. During the service.
Non-working period.
Yes, yes, yes.
Now, what is this communication? What is this order?
This order is the labor officer order, my lord, wherein it has in fact looked into all these aspects of break in service and the delay and answered in the.
So this break in service, he has been denied the benefits for 4 years and 1 month.
As per this order.
So, and this is the claim also, his claim.
Yes.
I don't think.
However, the learned single judge goes on the premise of delay.
That's right, that we have seen it. See,
yes.
Ultimately, this is a benefits for a
beneficial
workman.
legislation, yes, 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 yes.
Why should be on a technicalities, dislodge him?
Please, my lord.
The contesting, having said that, my lord.
But only on merits, if you see even merits, the reason for not giving is that for that 4 years and 1 month, there was a break in service.
Please.
That period has been excluded.
Yes, yes.
And break in service entails forfeiture of service.
Precisely. My lord, having said that, now the contesting respondent who had actually filed the writ petition against those orders, which looks into the break in service and the delay, and then accordingly orders the gratuity to be paid, is the Karnataka State Road Transport Corporation. And for that, there's a special counsel, Miss Renuka.
If you don't have any case on merits,
please.
Then what really follows? Let's assume for a moment delay latches the learner single judge has rejected. We are considering the case on merits also. In merits also, you would not succeed.
Please, my lord.
So I don't think we should take this appeal forward.
If the opportunity is given to my lord, I will definitely convince your lordship about the merits of the case, and he has got a very good case on merits, my lord. The Payment of Gratuity Act, as your lordship knows fully well, that it is a social welfare legislation, oriented welfare legislation, my lord. It has to be construed very liberally and sympathetically.
You're right, but that's the reason we are looking into merits.
Please, my lord, please, my lord.
You tell us, can a period during which the service period which is forfeited, can he be entitled for the benefits of gratuity?
My
You
humble
tell us.
submission, my humble submission, my lord. The specific order, in the absence of the specific
We will
order.
not go into those technicalities. We are only saying, okay, you may be just, we will consider that. Ma'am, just tell us one thing. Is there any order forfeiting the service of 4 years and 1 month?
There is no order, my lord.
No.
There is no
Then-
order by the corporation.
Then on what basis it is being said that there is a forfeiture of service of 4 years and 1 month?
There is not even forfeiture order, my lord.
Then
Except
I think, ma'am, he is right. Then he would be right. So we
Precisely.
want to know then we will issue notice to the corporation.
Please,
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 my lord. Please, my lord.
Issue notice.
that would be,
Issue notice to the corporation, to the State Road Transport Corporation.
that would be respondent number 1. I'll take notice for respondent 2 and 3, my lord.
2 and 3 inka just stop. And liberty is granted to the appellant to serve the counsel who appeared for the corporation before the learned single judge. Returnable on.
9-4.
Much obliged.
Much obliged, my lord.
For pronouncement. 44. P.A. Kulkarni.
Dismiss as devoid of merits.
Serial number 45. Srinivasa.
Lords, the issue is this, my lords. KPTCL issued a recruitment notification. In terms thereof, the only basis for determining the merit of the candidates were the marks scored in the aptitude test. Aptitude test was conducted. Then the KEA, that is the examination authority, which conducted the test, it published certain key answers. Objections were filed by the candidates. What had happened was that some of the objections could not even reach KPTCL because the mail showed its inbox was full. Thereafter, my lords, 1 or 2 candidates, they filed writ petitions saying that their representations have not been considered. And, what happened at that stage, based on the first published final key answer, they published a provisional rank list and provisional select list. Against that, more objections were received than against the original key answers themselves, because obviously number of objections had not been considered. Looking at the magnitude of objections received for the provisional list and the rank list, the examination authority and the KPTCL ought to have appear to have decided to refer the matter to an expert committee to ascertain whether the key answers are correct. For that exercise had been completed in the first round itself. Yes, ma'am. Examiner and then one committee, all those things had happened in the first round itself. Second round, they referred to the expert committee. The expert committee gave a report that 3 answers were wrong in the key answers. Based on that, the KEA revised the rank list and also the provisional list. In that revised provisional list, those 3, consequently, my lords, what happens is rankings will change because that was the only determinative factor. Even if one wrong answer is there, he loses 0.25. Negative marking is there for a wrong answer, 0.25. Because of that, it underwent substantial change, and in the revised select list and the revised rank list that was published, our names were there. Then one candidate, without making any person in the revised rank list or revised provisional list, he approaches this honorable court in the writ petition. That writ petition is allowed. Result of the revised key answers is nullified on 2 grounds. First ground is that these people had forgone their right to file their objections to the key answers when it was published at the first instance. Ignoring the, then it says, they had no right to extend the time. Actually, factually, time was not extended. What happened was, these 900 objections came when the when the rank list and provisional select list on the basis of the first set of key answers was published. And there were 1 or 2 decisions rendered by this honorable court in individual writ petitions that consider their representations. Those writ petitions, judgments are virtually nullified by the learned single judge in deciding the present writ petition, saying that in that writ petition, the court did not decide anything on merits. It only directed the authorities to consider their representations. No more, it is like saying, it did not decide on merits. Why? Because the court felt that it is a matter to be decided on by merits by the authorities. And normally, my lords, in key answers, my most humble submission is that courts are not equipped to say which answer is correct, which answer is wrong. Therefore, they always say when there is a dispute regarding the key answers, normally what is done, this court would remand the matter either to the examination authority or whatever it is done, except where on merits the matter is argued and this court comes to the conclusion that it should be referred to another expert committee. No such direction, simply mandamus would be issued. The learned single judge annuls the revised key answers, revised rank list, and revised provisional select list, which is made on the basis of the expert committee report, saying that these people had forgone their right to file objections because they did not file objections when they were called upon to do so. Second is, KEA had no authority to extend the time limit, or KPTCL had no authority to extend the time limit. These are the 2 findings given. My humble submission is, when an error is brought to the notice of the employer or selecting body, it is not too late at any point of time before the appointment is made to rectify that mistake and redo it. Because perpetuating a mistake is not heroic. Correcting the mistake is fairness and law. It is on that point we are before this honorable court. And the KPTCL in its objections before the learned single judge has categorically stated that because of the large number of objections we received, we referred the matter to expert committee. On that, no finding is recorded by the learned single judge.
My lord, I represent the KPTCL. We are led by Senior Counsel Mr. Nagan, and he is held up elsewhere, my lord. I won't stand in the way of Senior Counsel arguing the matter, my lord. I may be permitted to reply on another date. That's all. My request is.
Yes. let's see the finding of the.
The learned single judge judgment, my lords, is in the, that is, if my lords would kindly take the writ appeal number, my lords are having the soft copy of the judgment. Page number becomes irrelevant in this. Page number of the writ order, I'll say, my lords, instead of running page, because it writ appeal number 1204 of 2023. That is where I am appearing. Yes, my lords. Yes, that's I am doing. No, my lords. The learned single judge's reasoning, it commences, my lords, at para 9, page 21. In the light of the arguments advanced by all concerned, the only point that would arise for consideration in these writ petitions is as to whether the KEA possessed the power to refer the objections raised by the candidate after it had already published the final key answers. This is the question that he poses. As noted above, in the recruitment notification, the recruitment was to conduct a competitive examination, and this task was entrusted to the KEA, an authority which has been set up with the sole objective of conducting examination. The examination authority, an expert body, is conducting examinations, chose to issue a press note in which it stated that immediately after the examinations were conducted on 24/8/2022, the provisional key answers of all the papers would be published on the KEA website on 25/8, and the objections, if any, to the published provisional answer keys would have to be submitted with the justification through email on or before 2/9/2022. It was also clearly stipulated that the candidates, while submitting their objections, were required to mention the name of the post and paper, the version code, and the question number in respect of which they were filing objections. It was made clear that if these details were not furnished, the objections could not be considered. Finally, it was categorically declared that decision of the subject expert committee was final in the matter of finalized key answers. Thus, the key answers that were to be finalized after consideration of the objections raised by the candidates before 2/9/2022 were declared to be final by the authority itself in its press note, and this was to the knowledge of all candidates. This is the first reasoning. Admittedly, pursuant to the publication of the provisional key answers, objections in fact were raised by several people, and same were referred to the subject expert committee, who accepted the objections in respect of two questions, namely questions 24 and 25, and proceeded to award grace marks to them. The expert committee admittedly published a finalized answer key for all the questions, and by virtue of the press note, the finalized key answer was final and binding. It is also not in dispute that pursuant to this finalized answer key, a provisional select list was also published on 3/1/2023, and the objections were invited to the provisional score list. Obviously, the objections that were called for was only in respect of placement of the candidates in the score list, and objections when raised to the key answers could not be the subject matter of consideration since that phase was over on 2/9/2022. This is another finding, it says. The last day is fixed for raising objections. The objections called for was only in relation to placement of the candidates on the basis of marks secured by them in examination. It has to be noted that if any candidate chose not to raise objections to the provisional key answers published on or before 2/9/2022, he had basically foregone his right to object to the provisional key answers that had been published and had to accept subsequently declared finalized key answers. The KEA, by entertaining objections raised pursuant to the provisional score list published on 3/1/23, basically permitted the candidates to raise objections to the key answers, which had already been finalized and published on 27/12/2022. In other words, those persons who had not objected to the key answers were given a second opportunity to raise objections to the key answers, contrary to the press note dated 25/8/2022. The stand of the KEA that having regard to the large number of objections it has received, and that a direction had been issued in writ petition number 100378 of 2023. I pause here for a moment and say, that is the writ petition filed by opponent number 15. Here, to consider the representation of one of the candidates, to justify its decision to refer the matter once again to the subject expert committee cannot be accepted at all. If the KA had itself declared that the key answers were finalized after considering objections received pursuant to the publication of the provisional key answers, it obviously could not embark upon a second exercise in revising the already finalized key answers. In fact, this procedure fundamentally amounts to revising a list which had already been finalized, contrary to the authority's own declaration. It is therefore clear that the decision of KA to consider the objections that had been received pursuant to the releasing of the provisional score list of eligible candidates was totally without jurisdiction. This is the finding on which he annuls the entire thing. Consequently, any revision that has been made pursuant to the objections received after 3/1/2023 would be absolutely of no consequence, and as further consequence, decision of the subject expert committee to revise the finalized key answers by publishing another set of finalized key answers was non-est. That it will have to be held that the revised final key answers dated 4/2/2023 and the consequential provisional merit list published on 4/2/2023 cannot be sustained, and the same would have to be quashed. However, the learned counsel for the KEA put forth the contention that KEA pursuant to the publication of the finalized key answer published on keys on 2710 had only issued a provisional score list of eligible candidates, and that the same did not amount to a preparation of a provisional merit list. This submission would have to be stated only to be rejected. As could be seen from the recruitment notification, authority was fundamentally required to publish a list of candidates who have secured more than 35% of marks in the examination in the order of relative merit, as that was the prescribed percentage to be eligible for consideration for appointment. The authority choosing to give the said list the nomenclature of provisional score list or a provisional merit list would be of no consequence, since the list published after the declaration of the finalized key answers was a list of eligible candidates arranged in the order of their respective merit. The KAA was to conduct an examination, furnish provisional key answers, call for objections, and on consideration of the objections, published a finalized set of key answer keys, on the basis of which it was required to prepare a list of candidates who had secured marks of more than 35%. The authority did not possess any jurisdiction to embark upon a venture of re-evaluating the finalized answer keys. This is wholly contrary to judgment in Sahiti versus NTR University of Health Sciences. It is an inherent power of the examining body to correct an error whenever it is noticed, because ultimately what should inform any fair recruitment procedure is that, one, it must be fair to all. Second is, its evaluation should be based on reason and correctness. It is not that once an error is committed, because the last date is over, first revision, my lords, according to it, that is on 27/12/2022. Based on that, next one, my lords, what happened was 4/2/2023. And this arose out of objections received against the provisional score list, as also provisional select list. In fact, the first time consideration of the objections was so outrageous, my objection was not even taken up for consideration. I had no opportunity to produce this document before the single bench because I was not a party. In the writ appeal I have filed, how my objections bounced for the reason that KAS mailbox is full. Objections I have sent within the time limit, that is on 2/9/2022, which was within the time. Then, my lords, it was not received because I have produced the mail also. The email account that you tried to reach is over quota. Please direct the recipient so and so. This is in one case. I do not know what had happened in the other cases. But ultimately, examining authority found reason in those objections. In fact, they have stated so at page 266 of the paper book. That is, my lords, that is in page, that is in volume 2. It is stated, my lord. Make copy of the. Sorry. Yes.
Now in total,
Yes.
first revision of the search,
Yes.
the keys.
Yes, ma'am. Yes, ma'am.
Mistakes.
My lord, sir, three answers, I think, were this one.
Read the second.
Change between the final and the revised is 3 is what the learned.
Is three answers.
So the three answers key only resulted in the revision of this.
Yes, ma'am. Yes, ma'am. And more so because it was based on expert committee.
The paper setter,
Yes, ma'am.
his opinion. He
says, except in question number 35 and 72, there is no mistake, was his answer. But that was the first at all. But that was without considering all the objections, in the sense, some of the objections did not even reach the authority. Yes.
Objections which were considered included the objection.
It is quite possible. That I am not ruling out that, my lord. Therefore, I was very cautious in saying.
Was not there.
That is, no, there are two aspects to this part. One thing is the expertise of the committee which revised the key answers is not doubted by the learned single judge. Second is it is nobody's case that the expert committee opinion which resulted in revision is incorrect on facts. The veracity and validity of it is not doubted. It is not agitated. The only thing is, you gave up the option once. That ends the matter. That is, kindly look at this. Ultimately, the crux of the issue is this. After the three questions, my lord, sir, they were all objective type. Technical.
We may not have that experience.
Yes, well, generally the
Question itself is shown to be incorrect in two cases.
Which page?
Expert's opinion is placed before your lordship in a sealed cover. It was also.
I had no access to it. My lord.
They gave-
They gave, my lords, it is, in fact, my lords, it is there in this one. This is the expert committee report without excluding the names of the experts. They said, my lords, the conclusion was, in view of the missing letter capital R during printing, the question number 35 of version code A1 to be considered for grace. ಅದೊಂದೇ change ಮಾಡಿದ್ದು ಅವರು. ಹೌದು. And in the first page of that, provisional answer key published by KEAB. Both the first and second statements are partially correct. However, no such option under any key is given. Third statement under 3. That is, second page is this one. That is the first page. Third statement under 3 is an option B, C, and D. Fourth statement 4 is in options B and C only. Since both third and fourth statements are also correct, grace is to be awarded in view of the above explanation. That is in the first page. In the second page, question number 35, it comes to conclude that question itself is wrong.
opinion of the expert committee on the other question, because 35 is one question.
35,
Next page. Next page is 76.
76.
yes, ma'am.
And what is the other third one?
79,
Of the Arctic Council.
yes.
A to B and C.
Last paragraph.
It changed the opinion from B, C, D to B and C only. And it said, 79, what was it? Yes, this is only the 79, 76. I was in the report. 79 is, 35 is one page. 76 is
76 is the next page.
next page. And then,
And the persons who have sent the paper,
yes, ma'am.
they say there is no mistake or there is no error.
35 and 76. Nobody, we do not know what they say. Nobody. And what
They opine to give grace, my lord, for this.
the
They opine to give grace for all this.
Yes.
my lords will kindly take the statement of objections filed by the KPTCL. It is at page 253.
So the learned single judge basically is twofold. One, after that cutoff date for filing objections is gone by, you could not have considered the fresh objections.
Yes.
That's one. But your case is, look here, I have given those, sent those objections within the time period.
And some of us, my lord, said, I have placed on record only one appellant because I do not know the position about others.
Very well.
Yes.
And they say that they could not have constituted an expert committee.
Yes, my lord. He says, what that phase was over. That, my lord, that militates against the inherent right in the selecting body to correct an error. My lords are aware, my lords, even after the recommendation of an appointment was made by the Public Service Commission, in one judgment, Supreme Court, when it withdrew the recommendation based on verification of documents, Supreme Court upheld it.
So his final conclusion is the earlier merit is proper.
He doesn't say it is proper. What he says is,
You go ahead. That's what he says.
what he says is, it is binding. He says, it is, that is, as if it is a limitation. Limitation has destroyed your remedy. That is the finding. Now, my lords, coming back to, I was at
Mr. Rajgopal,
yes, ma'am.
just academic more.
Yes, ma'am.
If X prepares a question paper,
Yes, ma'am.
it is his understanding of those
Yes,
questions and the answers therewith,
yes, ma'am.
surely.
Yes.
And, it may so happen on one aspect, if two experts are there, they may have two different views, possible.
It cannot be ruled out at
That
least.
can't be ruled out. So would that be the person who has set the paper would be competent? Or a person who is not connected would also be competent to judge whether a particular answer is right? or not?
I would put it this way, my lords. Insofar as long as there is no dispute, question paper setter may be competent. But when doubts are raised about the veracity of the key answer provided by the paper setter, referring to another expert is not something that is prohibited. There are any number of cases where, why, my lords, after publication of the list also, the matter comes before this honorable court. finding some patent errors. There are cases and cases where Constitutional Court has appointed expert committee, which did not consist of the original paper setup. And on the basis of such expert committee, the constitutional courts have directed redoing. Therefore, my lords,
In an examination which is objective type.
in an objective type. For example, my lords, in earliest of the cases is Kanpur University case, which my lords are aware. There the test laid down by the Supreme Court is, in an objective examination, there can be more than one correct answer. But the question is, which is the most correct answer? That is the test laid down.
Whose perspective it should be seen?
That is, my lords, there is no taboo to refer the matter to another expert committee where there is a genuine outburst of dissatisfaction with the answers given by the paper setter himself. In fact, my lords, in Public Service Commission, first key answers are published based on key given by the paper setter. When the answers are received, it is referred to him only. Then there may be case where it comes into glare of attack. At that time, in fact, in Karnataka.
This 76.
Yes, madam.
Question,
Yes.
is it related to something engineering electrical?
I don't know, my lord. Because frankly, I did not go into that because.
Lords, if I may.
Just purely a general knowledge.
Next question is, my lord.
No, let's test it.
Yes, ma'am.
Purely a general knowledge.
Yes.
So experts, everyone is an expert because it's a general knowledge. Obviously.
But then, my lords.
And my lords, if I may, I'm sorry to
Yes.
intervene.
I may say so, my lords.
In respect of question 79, I'm sorry if Mr. Rajgopal doesn't
Yes,
mind.
79.
Please, I don't.
Such
I am
an
not even
apparent,
saying-
my lords, question. The question is, the only instance when the President of India exercised his power of veto is related to, and then there is, my lords, A, B, C, and D. I just checked the answer to this question, my lords, on ChatGPT. It is as clear as day that the answer is B and C because there are two, my lords, bills where the president had vetoed in respect of these four. So it's an apparent error. By
Mr.
using the
Sondhi,
word.
Mr. Sondhi, otherwise, see, and the judgments are there of the Supreme Court.
Yes.
When you are testing an answer to a question, you would not refer to the books. You would only see from the perspective that an answer has been given. See, like, there are judgments. Suppose we are considering as a court. I'll tell you an example.
Please.
A matter had come before me, and this is in the context of this only. It was a question relatable to labor law. Relatable to labor law, Industrial Disputes Act.
Lordships.
And surely having done some labor litigation, surely I was aware of it. But someone who has not done labor law, but has done some IPR issue, he may not be really well versed with that labor issue. He may have to refer to ChatGPT or Google search to come to a conclusion what is the answer. But the Supreme Court says, you will see from the perspective as when we are considering as a court, the court being aware that at least to the extent of the litigation having been done, that the answer is palpably wrong, then possibly the court must come to it. But if for something relatable to, electrical engineering which has come before the court will not take a view because
Great.
something which is not an expert.
And your lordships would not, in fact, substitute the view of the court for that of the experts.
Of the examiner,
Yes.
of the examiner, or maybe the expert,
Yes,
with our
ma'am.
own view. by
I'm so
referring to the
grateful.
books to say that this is the answer, right answer as per the books. That is not permissible, possible.
Yes, my lord, that is precisely what the learned single judge has done in error, which is to, my lords, doubt the view of the expert committee, which found these two questions, my lords, to be palpably wrong. It is not only demonstrable to your lordships, it was very clear to the experts that these two questions, in one case, of course, a grace mark was given. In these two cases, it was palpably, my lords, the question was framed wrong. The answer should have been 2 and 4 rather than saying only. And in respect of 76, in respect of 79, it should have been B and C rather than saying only.
But who are the experts? Were they
Lords, the
experts in electrical engineering?
The KEA is before your lordships notes. The report is there. Lordships may peruse that. So great.
Report, unsigned and dated, nothing. Your lordship has the report. That is the report.
Reports are here. We have blocked that. With regard to these two, my lord, the names of the experts are there, they have signed it. 79 is not the issue. It's not referred to at all.
Keep saying 71.
It is referred, I think.
Aspara is referring to.
What is this in view of the missing letter R? R is missing from 4, huh? Where is it missing from? Letter R. See, you don't require any expertise in this. Just an understand which everyone can understand.
But as an examining body, my lord, the authorities there are not experts.
And see the next question. Consider the following statements about the Arctic Council.
Arctic Council.
Where some, and surely it is also not something related to Arctic electrical engineering.
Precisely.
It is, my lord. It is that.
But
Yes.
Chat GPT is what my learned friend is saying. I went to Chat GPT because I had to give a lecture, my lord, on AI. It said, my lord, that in Estonia, my lord, there's judgments are given by AI. I believed it, but I wanted to test it because, my lord, somehow, my lord, I had an inkling that, my lord, it's not wrong. I mean, it's wrong. I went to Estonia website. Estonia, my lord, is that nation. It says, my lord, we don't do it. Today morning, my lord, in fact, one of my friend, Mr. Jan was giving me one of our senior counsel, they asked, Chat GPT about Uday Halla's biography. It says, my lord, he is an actor. He has, he has, my lord, been a movie actor in, my lord, 3 Kannada films, X, Y, Z.
Maybe there is a side to our senior we don't know.
Therefore, this, my lord.
ನನ್ನ ವಿಷಯನೂ ಅದೇ ತರ ಏನೇನೋ
He also says
about me also. But nothing defamatory has been written, therefore I could not raise it.
We just want law is very well clear. Kanpur University and all those things, even the
Yes.
judgment.
Yes, that has been correct.
We have to see within the scope of that. That's all.
That's the only thing.
And
Not only that, not only that, my lord, the rules are there. Rules of the game can't change. When they have specifically said, this is final, they can't, my lord, keep on saying. And then, my lord, my learned friend said, oh, we have sent this. Please look at, my lord, what they sent, which bounced back. It says, and send it again. Did they send it again? Answer is no. You all, my lord, they can create anything now.
It asks for send it again.
Please see, my lord. It says that, send it to Google. They have given that this thing. All that, my lord, I'll point it out.
I have placed on record, my lord, where my objection was returned on the ground that their inbox is full.
So you are the beneficiary of the second list.
Yes.
Right?
Yes.
We will hear the
Yes, sir.
the KPTCL. We want to hear it. What process you have undertaken this?
Yes.
And what were your rules of the examination? You will first exam is held, then you will put that's how it's followed. The answer key is put on the website for the candidates to check it and to assess their results. Any objection, time period, and you will consider those objections and then put the revised key, answer key.
Yes, ma'am. All that is done in this case, my lord. In fact, the KEA issued a press note which gives all the timelines and says that on or before this date at this time, please submit all objections. That was not done is our case.
You have also filed the appeal?
No, my lord. We are
Have not.
supporting the order. ma'am.
You
We
are
are supporting the impugned
order.
order. Yes.
Oh,
But there,
you're not. So when can we have Mr. Naganand?
Not any date, Your Lordship. May.
but their objections were slightly different.
We just wanted, I think surely everyone must be having all the
For
judgments.
KPTCL stand in the writ appeal, their sworn affidavit and objections were different from the stand that they are taking in the writ appeal. I'll be able to point out.
The stand is different as was taken.
Yes, this one. Before the learned single judge, they said that these were the reasons why why the reference became necessary.
Reference to the experts.
The experts.
My Lord, the single
I have
judge.
placed that on record.
You're right, because they referred the matter to the expert.
No, no,
Sir.
I think I was the.
KEA refer.
I was the
KEA
original
refer.
writ petitioner. That's KEA opposed me. KPTCL simply said, whatever KEA has given, we have culminated in the list. That's all that they said.
No.
They did not,
Who referred the matter to experts?
nobody, KEA did it.
KEA did. The
Of
examination
its own.
is conducted by KEA. Examination
Examination
is conducted by KEA. At the
And
behest
my
of
lords,
KPTCL.
pages 265
And
to
just tell us
267.
one thing, the setting up of the question paper is done at the KEA level?
Yes, sir.
That's their-
Not
there's
KE,
no
no,
second
they,
question.
they have a group, a group of experts.
No, you're right.
Yes.
No, KPTCL doesn't have to,
No,
has
nothing.
nothing to do with it.
No.
It's only make the reference to KEA, you
For
conduct the
recruitment to
examination. everything.
KPTCL, that is all. The examination is held.
All examiners, everything is appointed by the KEA.
KEA,
KEA
yeah.
get the paper set. Oh,
The Lordship may see the question framed by the learned single judge is whether the KEA had jurisdiction to. The question framed by the learned single judge, Your Lordship will find.
whether KEA has the jurisdiction to.
To
refer it to the
relook,
expert.
revise the already finalized answer.
We got it, we got
That
it.
is the scope of the.
When can we have it?
Your lordship permits, I'll just take 5 minutes.
Yes, ma'am.
So the expert committee's report minutes, the lordship's office just now. I learned it and question number 35 with 2 diagrams. If your lordship please take it.
That's right, that's right.
PQRS is the question number. There R is there. Third column next to R is not there. R is an input. If input is not given, output cannot be formed. That's a technical question. And kindly go to list 2, transform black diagram. Second,
Where is the R missing here?
in R, next to R itself, R is missing. And next to it, third line. Unfortunately, this PQRS is like ABCD, 1, 2, 3, 4. First PQRS, what your lordship gets, is like 1, 2, 3, 4. Next to P, if your lordship says, R, you will say RG is same. R is the input.
R is the input.
R is the input. If your lordships come to.
So the,
to R,
against S.
against R, there is no R.
Acha, okay, against R also there is no R.
Yes, there is no R.
S also there is no R.
Okay? These 2.
That's right.
Transform black diagram. 3, 1, 2, 3, 4 is there. There is no R at all. So when input is not there, we cannot assess as to what the output would be. This is a technical question. That's where they have mentioned clearly, in view of the missing letter R during printing, the question number 35 of version code A1 is to be considered for grace.
This A1 version, so 35 must be considered for grace.
Yes.
Question 35.
Yes. Error.
Very well.
This was raised at the first instance itself by many people that. we
What
were-
about the view on 76 and
79.
Down below.
Which of the above statements is correct? They have kindly come to 76. Which of the above statements is/or are correct? A, B, C, D, they have mentioned. But kindly see the expert committee's remarks. Both the first and second statements are partially correct. However, no such option under any key is given. Third statement is in options B, C, and D.
Only. Yes.
And fourth statement is in options B and C only. Since both third and fourth statements are also correct, grace is to be awarded in view of the above explanation.
see, if you see,
All these 4 answers will be correct. If we try,
If you see B, C, D, the common answer is Roman 3. The common answer in answer to B, C, and D, the options A, B, C, D, option Roman 3 is common in B, C, and D also.
That's where, my lord, this is one thing. One more thing is, my lord.
79.
79 they have answered, whatever it is. Now, my lord,
We'll check up that 79.
79, the question reads, my lords, that page 202 of my writ appeal.
79 is not there.
Is
It's not
not
a
there.
disputed question. Only these two are the,
Only these two.
only these two.
So revised list is based on these two.
Two only.
79 also.
my lord, actually,
79 they have given grace because more than one.
Okay, then we'll.
Lord, as regards examination procedure, I believe KA has to clarify, but we will also.
You appear for KE. Just say that we have heard learned senior counsels on behalf of the appellants to come up for the arguments of the respondents.
Mr. Naganand is logged in.
Yes, Mr. Naganand.
Matter that we heard,
Okay, then we just cut that, man. We will just cut that. Yes, yes, Mr. Naganand.
My lord, my submission, my lord, is that the learned single judge, my lord, has adopted that the cutoff given was very significant, and there could not have been any modifications or newer objections raised. That's the only ground, my lord, on which he has taken. Based on that, my lord, we have completed the admission process and appointments have been issued. There was a question raised, my lord, whether we can still accommodate some of them. That, my lord, my instructions are it's difficult to do so because it will upset, my lord, several other things which I'll be able to explain, my lord, why it's not possible now to redo the whole exercise.
We'll hear you, Mr. Naganand. I think
Please,
Those appointments have been made subject to the outcome of this.
Okay, we'll hear you. When do you want?
Anytime convenient to the court, 19th, 20th. Or
19, 20, just give it.
19th, my lord, I have some difficulty. 19th, I have some difficulty.
No, whatever is convenient.
20th, I have
Just
no
say
problem.
that we have heard Mr. P. Rajgopal and a senior counsel for the appellant. That's all. We leave it at that. Ma'am, we will hear you.
20th. I remember you said 21st.
20th, my lord.
21st.
Between all of you, we have nothing.
My lord, I remember we have, my lord, one saying in Kannada. Kappe takadi hakodu. That means, my lord, put the frogs into the scale. One frog will come in, the other frog will jump out, my lord. So
No, with these kind of counsels appearing, surely they would have to
No.
difficulty in
Yeah.
matching the date.
That's why.
You just tell us whichever is date convenient, please tell the
20th is fine, Manoj, because I think all
All
of
the
us are-
20th.
20th.
Please,
20th, Mr. Naganand.
please, my lord, 20th.
Thank you. Thanks very much.
Good,
Is there any
good.
interim order? It's made subject to outcome?
Yes, my lord.
2:30.
Yes.
No need to
No, madam.
continue it, no? Thank you.
Great.
2:30.
We'll
Grateful,
have it in the post lunch,
Yes.
2:30.
Please,
grateful.
Thank you.
please.
In the original secret.
ಮೇಡಮ್ ಇದನ್ನು ಕೊಡ್ತೀರಾ ಮೇಡಮ್ ಮೇಡಮ್ ಅದೊಂದು ಇದು ಕೊಟ್ಟಲ್ಲ
ಎರಡು ಪೇಜ್ ಅಲ್ಲ ಸರ್
ಹಾ ಇದು ಮಾಡಿ
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಒಂದೊಂದು
ಇಲ್ಲೇ ನಿಲ್ಸ್ಬಿಟ್ಟು ಇಲ್ಲಿಂದ ಕರೆಸ್ಬಿಟ್ರು ಆನಂದ್ ಬಂದ್ಬಿಟ್ಟು ಪೆನ್ಸಿಲ್ ಪೆನ್ನು ಎರಡು ಇಟ್ರು
ಬಂದಿದ್ ನೋಡ್ಬಿಟ್ಟು ಸೀದಾ ಹಂಗೆ ಬಂದ್ಬಿಟ್ರು.
Good. Just simple and moves.